Good morning. How is everybody? Hey, Judy. Hey, Jill. Hey, replay crew. Hey, lurkers. I my monitor's black over here. It threw me off, but it's supposed to be black. I'm okay. Never mind. It's just me being my normal, weird, unorganized, confused self. Okay. Um, I was thinking we might today, but we have a hearing to go to today at 1 o'clock. So, um, motion hearings in the Mickey Stein's trial, the sheriff that shot the judge. So that's at 1 o'clock. So we're gonna do this up till 1 o'clock, and then we're gonna go to Kentucky. So, um, so let's see what Judy has for us. Yes, please keep an eye out for my poll to vote for the next trial of the past. I've got actually I haven't checked to see if you guys gave me any more suggestions today. 1, 2, 3, 4, 5, 6, 7, 8. We've got 8 suggestions. All ones that I'm okay doing. Um, a lot of them are on the court TV website. I'm gonna try to find um YouTube court for them if there is, but if they're not, we're gonna be at the mercy of court TV again. You guys need to start sending me some more money. I'm gonna buy some more RAM for my computer. I think that might fix the problem. Um, because I'm sure not everyone has this kind of problem with their website, or they would have fixed it by now. So it's probably the RAM in my computer. But maybe I'll ask for that for Christmas. I'm getting a scooter for Christmas though. That's gonna be expensive. I doubt I'm gonna get anything but a scooter if he's really getting me that. That's probably all I'm getting. The jury told the judge that his special instruction number 3 was the problem in a hung jury. And his final instructions to the jury, Fiddler said, "It is the prosecution's theory that the act committed by Spector that caused the death of Miss Clarkson was to point a gun at her, which resulted in that gun entering her mouth. If you do not find that the prosecution has proved beyond a reasonable doubt that the defendant committed that act, you must return a verdict of not guilty. If you do not find that the prosecution has proved beyond a reasonable doubt that the defendant committed that act, you must return a verdict of not guilty." Hang on. I think it's too early. It is the prosecution's theory that the act committed by Spector that caused the death of Miss Clarkson was to point a gun at her, which resulted in that gun entering her mouth. He pointed a gun at her, and she died. If it didn't get in her mouth by him doing it, I don't understand. Like I said, it's too early. So, if he got the gun out and pointed it in her face, but she grabbed it and put it in her own mouth, does that make him not guilty? Like, what is that supposed to mean? I don't get it. Good thing I don't go a go sit on juries. What? Good thing I don't do jury duty. That's what I need to say. Can't even think. Yeah. Why couldn't they have just said that he pointed a gun at her? Bye, baby. But why? Why would you? That's stupid. Do they think that she grabbed it and put it in her own mouth but didn't want to be shot? Like, I don't know. I'm confused. I don't like it either. I don't like that instruction either. It wouldn't have hung me up though. I would have still said he was guilty. I mean, that's a weird instruction. It is a weird instruction. That's why this is the face. That's why it's confusing me. Yeah, it's a weird instruction. Yeah, I am too, Jill. Yeah, it's a weird instruction. But I still don't see how it resulted in a hung jury. My eyes are watering. This has been going on for a couple days now. I'm leaking. Do I have too much water in my body or something and it needs to escape? Like, why am I leaking? Oh, wow. So, you guys, you know how like we decide guilty, cuz we can talk about it and stuff. But even before a defense case goes on, we decide guilty most of the time. If you were on a jury, would you, because they always say keep an open mind, don't decide anything yet. But would you guys? That was delayed. Well, she's lying. Because I watched her do them. They're all over my arm, all over me. But if you guys were on a jury, would you sit there in the jury box and say, "Oh, he's guilty," like in your head, like we do? Like, would you go into the jury room and be like, "Oh, he's guilty. I don't even need to look at anything," or would you sit down quietly and wait till everybody started going through all the evidence and then give your decision? I don't think I could do that. I think I would go in there and go, okay, he's guilty. I don't think I could patiently go through all the evidence without telling everybody what my opinion was. But you guys know how I am. I tell everybody what I think all the time. I'm not shy when it comes to my opinion on things. Ooh, pretty.
Parties, jurors, and documents are present as here before. You may resume.
That before.
Thank you, Your Honor.
All right.
When we left, I said to you, someone once said we are entitled to our facts, but no one is entitled to his own facts. We're entitled to our own opinions, but no one is entitled to his own facts. Despite the fact this to be a self-inflicted, the fact was a recommendation to do so all because they, as I told you before, don't find the facts, and they didn't find it, and not find it because of theory. But we want you to go out what I tell you, what you see. You search for the truth, you seek the truth. The government wanted this tragic death to be a murder. No one wanted to stop that steamroller. No one wanted to get in the way of discussed a few things that one of the calls was autopsy. We also discussed the fact that if the evidence had been reviewed, it clearly would have stopped the investigation into Philip. And more importantly, it should have directed the investigation toward the decedent. If they had done that instead of fixating on Philip, you saw, and Dr. Pena never saw for the first time in this courtroom. Now, one of the earliest emails that was read to you, that was available at the time, was written in 2001. Ms. Clarkson discussing the fact that she's hurt herself in the past, and on the night that she died. You saw that in opening statement. That was the first time that anyone had paid attention to that or looked at it. Dr. Pena had not seen it. The police didn't look at it, and more importantly, as I said, no one from the coroner's office considered it. You also know that in
Yeah. Like he was pointing at 1 minute and it ended up in her mouth the next minute. Or like he tripped and it ended up like it was almost an accident that it ended up in her mouth or something. Yeah, that was weird. I have another question I just thought about. I was looking back at some of my more recent live streams to try to figure out this microphone thing, and I couldn't hear the goat. I could see me use the goat, but I couldn't hear the goat. Do you guys hear the goat? Do you guys hear it? Because I know on Brandy's stream one time, we couldn't hear her goat, and she said it because she had noise cancellation on. So that might be happening. Are you guys even paying attention to me? You're actually talking about the case and ignoring me. That's a new one. Pay attention! I'm asking you a question. So you can hear it now? They both drink. Yeah, that's double. No, double standard. Yeah. What? Like a woman can't drink, but a man can?
She had the blackout drinking periods in the letter to L.B. Moon. And you don't have to take my word from it. These were her own words. This computer expert in 2004 after Philip was charged with the homicide, but it was never read by the coroner. In May of 2005, after Philip had already been indicted, a box of documents concerning Ms. Clarkson's mental statement was sent to the coroner's office, but it did not include all the documents because the computer had not been looked at and been ever taken until we brought them here until trial. Dr. Pena's superiors made a determination to lock that box away in the closet and never show it to anybody. Lock it in the closet. Now, what else would they have known if they had directed their investigation towards her? But we know she had a history of alcohol abuse and pain addiction. If they had bothered, they would have learned that she tried to become successful for only 30 days and failed. That's a tragedy in itself. They would have learned that she was so financially stressed and emotionally distraught that starting in December 2002, she wanted to chuck it all. In fact, take a look at Lana Clarkson's own description of her own mental state near the time of her death. Jen, could you stop? Over here, things are pretty bad. I won't go into detail, but on the verge of losing it all, just hanging on by a thread. I'm at the end of my rope here. I cannot function under these circumstances any longer. I don't want to take so much medication, yet I seem to have no alternative right now. I am going through a difficult time right now, the worst I have ever endured in this lifetime. I'm not certain what my lessons or karma are, but I'm truly being tested almost on it. Sorry to be so rude. I am and watching the fires, looking at all the strangers, happy couples, people with stomachs, and families with normal lives. I'm working several jobs and still struggling to keep my house. This has been hands down the most difficult I have ever experienced in this lifetime. I am beat up physically, emotionally, and spiritually. This has been the most difficult difficult year of my entire life, and has not gotten any better. Financially, my life is in shambles, and I'm on the verge of losing everything. Kind of strange position to be in at this age. The cowboy canceled his trip out here, and I was with a cup of coffee and cookie someone had left on its cafe table. Shit, man, this is
Rude, StreamYard. I was talking. How do you afford pain pills and alcohol if you don't have money for food? 'Cause- 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 'cause-
about Miss Clarkson, how she was feeling, than looking at her own words, which she herself, anyone if they wanted to find it. If the government had bothered to look at Miss Clarkson's mental state, they would have learned for the 2-month period beginning in December 2002, or she had looked for to try to make a psychological counseling appointment with Mary Goldenson, who we brought here before you. If they had looked at her day planner, they would have seen that she had a couple psychological sessions with another psychologist that was noted in her 2002 day planner, a Catherine Bainbridge. They would have learned that she was the likes of which her friends had not seen from her, such statements of depression that even the death and available to the prosecution in presenting this case. This would try to give you the full picture of the circumstances surrounding the evening of February 3rd, 2003. We have not, as has been intimated, presented this evidence to assassinate her character in any way. Youthful, the one that normally would have only been available to the investigators and the coroner if the appropriate investigation had been done. The government has talked about Ms. Clarkson's state of mind as normal ups and downs and equated her depression to a football fan after his team loss. Do the emails that you saw and that you will read fully and making phone calls for her depression started at least 10 years ago when she went to a mental health counselor to try to get treatment in 1994 and then apparently couldn't afford it or didn't seek it. There were confessionals to friends. That, ladies and gentlemen, is a lot more serious than the normal ups and downs that a football fan experiences. The government is minimizing Ms. Clarkson's problems because it doesn't fit their theory that Phil Spector killed her. What else do we know about Ms. by losing her youth. She'd even resorted to forging letters to say she was better than she was. That, obviously, these are from her own reckless activity, and people do stupid things.
You. Thank you, thank you, thank you. I was kidding. I was not serious, but thank you so much. I swear I was kidding. I didn't really mean it. But thank you. Oh, I appreciate it so much. Thank you so, so, so much. Oh my God. I can't believe you just did that. Thank you so much. Oh my God. Thank you, thank you, thank you. Hey, Carla.
But the risk factors of alcohol and drugs, you can't pick up a paper and not see something reckless happen for somebody on alcohol and drugs. She was desperately trying to deal with her pain instead of trying to deal with pain. She was on the brink of bankruptcy, despite thousands of dollars. The rush to take her away from and weeks, but simply put, the phone had really stopped ringing. A few hundred commercials in 1 year not negate that fact. The government's own evidence and ours tells us that the career was the main focus of Lana Clark's life. She'd given back for this career. They did not talk about the other plans she may have had to marry LB to take her away from it. The government told you about the happy and hopeful Lana Clarkson. They did not tell you, they did not want to know about the other dark side, about her depressiveness, because it did not fit into their theory of the case. The fact is that both these Lana Clarksons exist, as do in many people. You know, people are not all good, they're not all bad, they're not all happy, and they're not all sad. People can be both fundamentally
I hope we don't have to watch the last of this trial like this. Come on, StreamYard. And I might have to, the next trials from the past, I might have to do a YouTube one. Because this is so getting on my nerves. Until I can get the RAM for the computer. I guess I need to start researching. Because I know how to work on a tower, but this is an all in one. So I don't even know how to get. Because RAM is different on an all in one. It's like a cartridge thingy that there's a something on the back of the monitor that you take off and you just put the cartridge thing in or something, and I don't know. This is aggravating. Belle is doing better. Um, Her urine had cleared up, but now it's starting to have some blood in it again. I couldn't take her to her follow up appointment because of the storms. When it storms really bad, because we live out in the middle of nowhere, and my jerk neighbor had the road closed, so the only road out of here, our county won't maintain, even though it's county road. So there's great big giant holes filled with water every time that it storms, and my Mustang cannot get out. So I am stuck in when it storms, and it storms pretty much every afternoon in the summer in Florida. So I am literally homebound. I can't get out. And the county doesn't give a damn, even though I've complained, I've called, I've gone up to the commissioner's meeting, I have left messages, I have emailed. They don't care. Even though I have worked at both nursing homes in our town for many, many years, and they just don't care. So I get homebound when it storms. Yeah. Um, it it ticks me off because his wife works for the school board, so I guess the county thinks he's more important than I am. I don't know, but yeah, it ticks me off, but it is what it is. So there's a field, there's a field that's parallel. While I'm talking, I'll just make myself full screen. There's a road. The road that we are supposed to get out on is parallel to a field, and there's a gate here and a gate here. So what everybody has been doing, and it's made like a path through the field now. You go in one gate and you drive through the field that's parallel to the road, and then you go out the other gate, and then you go down the road, the road that they grate and take care of, and then you go down that road and you get out. You just don't use the road anymore. The field is actually a better passage than the actual road is now. So it sucks. Come on, StreamYard.
That was ever going on with her life, she felt the need to forge letters, to talk to them, try to get money from people. Depression at that stage in her life, it's not surprising. Lana Clarkson, it was very good at putting on a good face on her desperate situation. But a person can be both positive on the outside and when Mr. Dick's cottage, whether it was a mess, because you remember Lexon said she trashed her cottage at one time. Mr. Dick asked, like someone didn't take care of themselves, like, I don't know, Owen Wilson. He continued on a wedding crashers, and it wasn't that a prescient comment. People can put on a game face. People at the top of their profession
Yeah, that was my fault. I tried to put a comment on the screen. Yeah, Aaron's coming, and when we have hurricanes, trees get knocked down over the road. So I can't even take our handy dandy shortcut because tree. um, so Travis can't even get out to work, or he has to drive through like a cow field where there's not a little trail. It's like, I mean, he has a Ford 150, so like cow field, like lumpy, bumpy, like hurts me because I'm, in pain all the time. And so, like, even with the seatbelt on, like, you're bouncing, hitting the door, hitting the ceiling, all over. It's a rough. So, yeah, it's not fun living out here sometimes, but I'm out in the middle of nowhere. I don't have to worry about neighbors. I don't have to worry about crime. So, like, it's in a way it's good, but in a way there's pros and cons.
That wasn't seen by others. You don't look because maybe you don't want to find. How does depression manifest hers? Well, we know that she had pain and addiction, major withdrawals from pain pills, falling in and out of love, trying to stay sober, totally broke. Hey, I have more serious addictions like pain pills. I hurt myself, of course, injured as usual by tequila. I was not kidding when I told you this has been the most difficult year of my life. Blackout drinking quote again. First day sober. Eating 1 month. She chose to drink and she had a problem with drinking in the past. We saw about her addictions, and you'll have them there, the whole story, the story that Dr. Pinney didn't have and the government never looked for. In August, where she said she was first day sober, she tried to come off. But obviously that didn't work. When we talk about killing oneself, accidentally, intentionally, because you have risk factors, what does that mean? We don't say that somebody intentionally plans it. Dr. DeMaio and Spitz told you that suicide for a forensic pathologist may merely mean a self-inflicted injury based on a reckless act. It could be spur of the moment. It could be accidental. As a matter of fact, you saw a coroner's form from the Los Angeles County Coroner's Office that said suicide-accident on it. It's not an unheard of concept. All it means is that it's self-inflicted, maybe because of risk factors. Dr. DeMaio and Dr. Spitz said they would have assigned it a suicide because they didn't know whether it was intentional, planned, but that's what they would have signed it. Dr. Bodden said he believed it was a reckless accident based on the risk factors. Whatever the reason behind it, that's for you to discuss. That's for you to discuss. The science shows that the wound was self-inflicted. That is not a mystery. It never has been, if you wanted to look. The reason why it was self-inflicted, that's the mystery. That you'll discuss, but it's not necessarily for you to decide. The fact is there is ample evidence for the coroner, police, and the government to find that Lana Clarkson number of reasons why she could have shot. We will never know how deep Clarkson's depression was because a psychological autopsy was not done. done by the proper professionals at the proper time. Did she think about what it would be like without intending to pull the trigger? Was she playing with? Was she for a movie role? Was she putting in her mouth for some other reason? The gun go back. I understand that government's ballistic, if you recall. If you've got your finger slightly on the trigger and it's slightly pulled back the hammer, can the gun go off accidentally? Because it's a Saturday night, 38. And the answer was a resounding yes. That, ladies and gentlemen, Peck you was something called a snap fire. And remember in Dr. Cidia's
Okay, go. Hammer back. Take your finger off the trigger when you do that, please.
Yeah.
Take your finger off the trigger when you do that, please, when you start pulling the hammer back. Because if you've got your thumb on the trigger or finger on the trigger and it's slightly retarding it, gun can fire. So I say again, did it accidentally go off? Was she playing around? Was she acting out a scene? Or was she feeling the gun from memory for a future scene? Or did she hit rock bottom? A lot of talking should have been done. Once the science showed this was a self-inflicted wound. And let's get over the idea that the gun was secreted with Phil Spector's bullets and Phil Spector's draw. It's very clear evidence that Phil Spector tells women when he first meets them that he has or carries a gun. Rami Davis told you that. He told Rami Davis. He told Rami Davis, and he said he told her that he tells women that he carries a gun in case they're upset with it, or has a gun in case they're upset with it. He told Lana Clarkson, since it was its first time he'd met her, that he had a gun or carried a gun and that he had put it in the holster and put it in the drawer when he came home. She wouldn't know it was because it created. By the way, did you see the pictures? Oh, was even on September 4th when Mr. Rentieri was there? You'll go search for him. That drawer is still open. Did it get stuck? Is that the way it was? But in any event, Rami Davis told you why she could have known there was a gun. Not because it was secure. She had got the gun. She had it. Her DNA. On the.
Okay, I know. Oh, there you are, just because. I know we've had this conversation before. It's secreted. Secreted means something oozes out of it. The word is secreted. Out a scene? Did he make her think he making her act out something? Yeah, who knows? Am I going to crash StreamYard by trying to put comments on the screen? Who knows? So is this is the first time I've heard this. So he had it with him, and that's how she knew where it was, because he took it out and put it in that drawer, fully loaded. Sure. And the word is secreted. Secret ed. Secreted. Not secreted. Secreted means something oozes out of it. It's not. But why didn't they bring this up during the trial? Because closing arguments is not evidence, and this is the first time I've heard. Well, this is how she knew where the gun was. I hate it when they say secreted. It's secreted, right? Isn't that the correct way to pronounce that word? They're both spelled the same, but you're talking about two different things. It aggravates me.
Not Philip Spector's. She held the gun and she retarded that trigger. Whatever happened in her life, that's could have sympathy for. The government in this case told you we're smearing the victim. I guess I said are only good or bad. And they depend on this world's view to say that Phil Spector is a bad man and that Lana Clarkson is a good woman, therefore he must have shot her. The fact is, like most of us, neither Lana Clarkson or Phil Spector are entirely good or bad. Most of us, like every person. What the government wants you to believe is that Phil Spector is a dead man and he shot her. They want you to hate him and supplant the facts of this case with that hatred. They want you to use emotion to convict Phil Spector rather than rely on the scientific evidence that clearly exonerates him. That if you are Lana Clarkson, you will want to convict Phil Spector. And wouldn't it be so easy to convict him on that basis? So easy because you hate him from what you've heard. Wouldn't it be so easy? But it would be so wrong. How does the government tell this story in order to get you to hate Phil Spector? First, they portray Lana Clarkson as a happy, hopeful, vulnerable, and naive. They know that if they portray her in this way, you will reasonably conclude that Phil Spector controlled all of the events that night and that she had no choice whatsoever about going back to with him or leaving. This is the story of the terrible victim against the madman. We think you should feel sympathy to Lana Clarkson. It is a tragedy to her family and the law. Any child dying before a parent, tragedy. Anytime. In fact, you heard from Dorothy Melvin when she told you that she had had conversations with Philip about the death of his 9-year-old son. She told you that she had conversations throughout the whole time with him. She told you that. But that doesn't mean you don't look at and lose as a child. But that's not what's involved in this case. You can feel sympathy for her and still look clearly at the evidence. As a matter of fact, it's important to you. It's important to you. And you have sympathy for her to understand why she made that gun and put it in her mouth. Her friends, her closest friends, even though the government told the whole story, because the only true way to be someone's friend is to tell the whole story. And the only way to bring truth to our system of justice and let justice recognize truth is to be forthrightly honest, not cowardly intimidated by the mob. The government tried to undermine the clear reliability that Irene Elizabeth Laughlin you a picture that you will be able to see in the jury room that's in evidence that clearly showed that that implication was false. There's the wrists. That's what the happy new year, that when there was some implication that she was lying about that being her birthday party because a happy new year. And Pi said that was her birthday party, but they were wearing happy new year crowns, kind of like I'm celebrating the new year. That's the cast on one of the wrists. It was there for everyone to see, but you have to want to seek the truth. You have to want to look. Let's talk a little bit about Pi. Pictures, the emails, the date books, the testimony from Greg Sim, Jennifer Hayes, Tamara Hansen, even though the prosecution tell their story to you of a happy Lana. Maybe we laughed when Pi first, and it was made allusion to yesterday, when Pi first came to this courtroom dressed or undressed, depending on how you look at it. But remember, Lana Clarkson chose Pumpkin Pie as her best friend for over a decade. And if we laugh at Pumpkin Pie, we are laughing at Lana Clarkson. Case. They have attacked, ridiculed, denigrated, and scoffed at anyone who would dare say anything that might in the slightest contradict their theory of the case. They denigrated experts who said they believed this was a self-inflicted wound on the basis of science as being biased. The government wants you to believe that these people would rather go to their graves, putting hundreds of collective years of their reputation on the line for someone called Phil Spector. They want you to believe that these men of science, the same science that's responsible for freeing the unjustly convicted and convicting the justly properly, would rather go to the grave under a cloud of impropriety. Firefighter for the city of Los Angeles, and implied that he was a liar and wouldn't let him tell his whole story until Mr. Rosen got up on redirect. And let's play that clip. Let's remember of how.
I'd like to point out something to you, if I may.
I'm sure Mr. Rosen will ask you to point that out.
Okay.
That's all I have for this witness. Redirect.
Point that.
Let's see.
Okay, I'm basically being cross-examined here, and you're trying to state basically that the way I'm taking it is that I'm a liar.
And then he went on to discuss why the form showed that he was right, that there were two separate sets of times in that form, if you recall, that indicated that Mr. Liverpool had been wrong. But these type of attacks from the government have been all too common. In this case, from the time they started, because they were willing to open up, look at to seek the truth like we're asking you to do. Anytime anyone deviated from the story, they have been, even Pumpkin Pie talked about how she felt bullied. But there is a way to cross-examine witnesses, a way to treat witnesses, a way to try to get information of witnesses so that you can identify education, knowledge, just a basic human being attitude, both everyday people, experts, and professionals. We hope that we were at least successful in bringing some of the truth to you, and if we've done anything wrong, please don't hold it against us, but do not hold it against Phil Spector. We want you to have all the facts for you to consider. You're going to be taking the deliberation room, trying not to keep anything from you, because the trial is only getting to one location, a location of a place called win at all costs. A trial is about a search for the truth so that you can honestly and forthrightly discuss your opinions and come to a very serious decision. Why would the government treat everyone who dares to disagree with them with such malice and contempt like Pi has been treated, rather than merely rely on their own evidence, the scientific evidence and the other evidence? Are there attacks because they don't have a strong case and desperately need to tear down the character of these witnesses because they cannot tear down what evidence witnesses are bringing to you unless they tear down character? The government has excoriated our expert witness and pedestaled their own. They imply that our experts have no ability while theirs do. By the way, their accountability is to the government that them. They work with these people all the time. They all get paid by the same entity. They all have pension plans. They all have friends. So let's look at the experts in this case. Dr. Andrews, Dr. Pena, and Criminalist Herald have never been to the scene, Dr. Penny said he hadn't been to the scene of an intraoral gunshot wound. Dr. Andrews had never been to the scene of an intraoral gunshot wound. Dr. Herald had never even seen an intraoral gunshot wound case. As a result, they may not have seen actual blood spatter under those circumstances. This is a unique situation. Dr. Penny said he hardly goes to scenes at all. Dr. Spitz, DeMaio, and Baden have gone to thousands of scenes and have seen many oral gunshot wounds in their commensurate spatter effort. The investigation notes and ridiculed the experience performance. Well, I don't have files to drop at you, but you heard that Dr. Spitz, the lead book in the country, 10 pounds. You heard that Dr. James, lead book. Dr. Lietzma, lead book. Dr. James Kish and Miss James, I'm sorry, another book. Dr. DeMaio, book. And you heard about Dr. Lee, who they accuse of evidence, book. Representative of only some of the experts in this case. This is their life work. Not all of them are retired, as was hinted to you. One works for the New York State Police. Some work for the other law enforcement agencies around the
Okay, StreamYard, this is enough. You're getting on my nerves now. Knock it off.
And oh, by the way, all three testified their fees are consistent, whether they testify for the prosecution or the defense. Evidence was misstated when they submitted to you, the government submitted to you, that some of our experts did not consider Philip's history. Not true. They did. They told you that on the stand. I was here for two of them, and you'll have to remember for your judgment on the third one. And they divined that it was irrelevant to and who put the gun in the mouth of Lana accounts. Because that's why we have science. That's why we have government labs. That's why we have crime labs. That's why we have trace evidence. That's why we have DNA, GSR, blood spatter, and other areas of forensic science to specifically discern scientifically so that judgments aren't wrong. Judgments are wrong in very important decisions. That's why it's done, because witnesses can be wrong. And emotion, findings, then their findings must be scripted. But has the government ever considered that the experts are in agreement about their findings because they are true? Because they are the hallmarks of what every scientist uses, just like mathematicians have hallmarks, just like everyone in their profession has certain hallmarks by which to judge things. The government has conceded a number of points. They criticize our experts, but here are some of the science they have not disputed. The government has agreed on the trajectory of the bullet path. They have not disputed that the blood spot on Philip's tricep part of his coat is spatter. As a matter of fact, they're the ones who found it. Therefore, it is their burden to explain. You cannot say, well, maybe it occurred sometime else. This is a case in this court today for proof beyond a reasonable doubt. If he shoots right-handed, there is no explanation for how it got there aside from the fact of Philip throwing up his right arm to protect himself as Lana Clarkson shot herself. You heard James Pex tell you that blood spatter does not turn corners. There is no blood spatter on Philip's coat cuffs on the lower coat sleeves. No one ever came and testified differently. And the arrows don't indicate to that. There's one arrow here on the left, which Mr. James told you was a transfer stain, was never disputed. There was no blood spatter or tissue on a shirt. There were no smokeless particles on the shirt, except for the blood in one of the left. There was no trace evidence in his pockets. There was no blood spatter or tissue on his pants. There was no smokeless burnt or unburnt particles on his pants. There was no trace evidence found by the forensic nurse on his face or body. If he shot her, his entire arm would have been enveloped by the 2-foot radius. There's no blood spatter or tissue on any of his other clothing besides his jacket. There's no blood spatter travels at least 2 feet. There is no evidence of blood or tissue or any physical matter in any of the drains of the house. There is GSR in Lana Clarkson's lungs, and the teeth on the stairs were projected there by the gun blast. These scientific facts are not disputed. By not disputing, they have not disproved this evidence. Inmates agreed with exactly the same evidence that are presented. If Philip shot Lana Clarkson, his hand would have to be holding the gun, unless, of course, it fell into her mouth. Under every scenario presented by the government, Philip's right hand, coat sleeve, and shirt would have been in the 2-foot radius of that cloud. Therefore, if his hand was there, the right sleeve, at very least, would have blood spatter. The government says the blood spatter would normally be there, and then try to explain why it's not. Since it's not the government agreement, it's implicit, reasonable. Additionally, they not dispute there's a GSR in the lungs, and have not presented any evidence except how it got there, except that she could have breathed in. It's certainly GSR didn't get there by gravity. So it's reasonable for you to conclude that GSR was aspirated into the lungs, which had to occur after the gunshot, after the gun went off. Therefore, Lana Clarkson had to have taken at least one post-shot breath. And since we know that whatever she has breathed in has to be breathed out, this could also account for some of the spatter on Philip's jacket. A rebuttal won't be able to. If they can show you an evidence where they have refuted these items, then you can test the weight of each side's evidence. You test the weight on those issues. However, if they can't, that's reasonable doubt. talk a little bit of Mr. DeSouza. The government to make evidence fit their theory. Remember, I discussed with you that it's very important to be objective, fair, unbiased. Barbara Nelson from the coroner's office told you it's important to challenge and verify statements made by witnesses at the scene while you're doing an investigation. Coroner investigation Nelson told you that you should challenge and verify these statements. No doubt about it. Now, criminalist Nelson did not have the statement. If we could put that back up, Jen? And just leave it there for a moment, please. But you can only do that if you are given all of the information. We are asking you to look at all of the information, as much as could be brought to you in a trial, so that you have the complete picture. We may be a defense team, but we speak with one voice on this issue. And Phil Spector has been accused of having a checkbook defense by hiring a team of lawyers and experts. But unlike the state of California, we don't have an office with hundreds of investigators, hundreds. Before I do forget that I do thank you for letting me into your state and into your courtroom. I know it does not matter to you where I come, because ultimately we all come from and go to. Prior to you hearing this evidence, we know that the police determined that this to be a murder on day one, and fit every proverbial round peg into a squirrel to support their theory. You will have the log in there for their crime scene. The coroner was not even on the scene at 6 p.m. on February 3rd. A cause of death had not been, and yet even prior to him on the scene, Mr. Dixon, who's a very fine attorney, was seated. Crime human of the DA's office was already at the home of Mr. Spector. Dr. Pena hadn't even gotten there yet. Don't take my word for it. It's in the log, and you'll have the whole log to see how many people were at that scene. Now, what happened? The physical evidence showed that Phil Spector was not the shooter. But the cops, instead of challenging and verifying the investigation, immediately bought into the story of Adriano DeSouza, that he had heard Phil Spector say, "I think I killed someone," or shot some, depending on whose version or whose report you heard about in court here. Let's walk through for you to see, and you'll have all of it in the jury room. Let's walk through, see what you see, go through a little bit how that statement came to be. First, in a 911 call, Mr. D'Souza does not say here's what the truth is. It says, "Yeah, I hear the like a noise." And then he opened the door and, quote, I think he, dash, dash, I killed her. I suggest to you, ladies and gentlemen, you can infer that Mr. DeSouza was about to say, I think I heard I killed someone, but he was not sure. But today, those three words morphed into the certainty of 5 words. Or was it, someone's been killed? Or was it, she's been killed? Or was it, I think someone's been killed? Or was it, I think she's been killed? His uncertainty was manifested on day one, the same day when he said to Investigator Fournier on February 3rd, 2003, about the transcript that was recorded that Mr. DeSouza did not know was being recorded, reading What again? He says, and you say, I think I killed somebody? Fournier, I killed somebody? De Sousa, yeah, somebody. Fournier, okay. De Sousa, I think so. I'm not sure it's my English. That was on the first day. I'm not sure it's my English. This is extremely important because no one ever heard about it until we brought it to you in trial, including the coroner. What he had was the state. If we could, Barbara Nelson quote, is that possible? That you had before? Thank you. This was involving a question I asked Ms. Nelson. Had you heard about the contradictory statement of Mr. De Sousa where he said he wasn't sure? Because she heard Mr. Spector said, I shot somebody or I killed somebody or whatever it was. And she didn't. And if you had, hypothetically, another statement was contradictory, which I think, I'm not sure, is contradictory, would you have wanted to know that? Yes. Yes. Any trained investigator would want to know of a contradictory the same day that says, I think, I'm not sure. Because the words I'm not sure deserve as much credibility. And they are just as important as the words, well, maybe he said this. I am not. When all you have in a case that allegedly connects Phil Spector directly to any shooting are those words of Adriana De Sousa. Even more importantly, I want you to go through transcript prepared by the DA's office with the quote, and quote, I killed her. Take the quotes out. And then he opened the door, and I killed her. There's no attribution to Mr. Spector saying that unless you or somebody who types the transcript puts the quotes in. And you heard yesterday the call to Michelle Blaine. There's no indication that Mr. Spector came out and said, I shot somebody, I think I killed. It's not easy. You listen to the tape. And then he opened the door and I killed her. And if you look at what's said objectively, when there's no quotes, was he saying he thinks he killed her, but he didn't? No. Or he mixing up his pronouns of I. Because you heard him at trial and he mixed his pronouns, and we're going to show you a lot of that in a bit. He mixed up I, he, she, and a lot of words. And we're going to show you a sampling of some of those in a few minutes. Ladies and gentlemen, Mr. De Sousa had the classic problems of any witness, whether it be an ear witness or an eyewitness in a stressful situation. He was simply mistaken. And he told you he wasn't sure on day one. 5 little words, only one of which that could be so easily misheard, that the total difference misheard from his native Portuguese language. So was he working hard 20 hours? He talked about the air conditioning unit running, and the radio was playing in the car, and there was opera, as you've heard, in the background of the house was playing. Now, you were at the house. Fortunately, I wasn't with you that day. So I leave it to you as to the confusion of maybe one being mistaken from asleep. Mr. Sousa was seeing the body. Okay, in any event, you heard a sound that startled you, right? Yes, you woke up. Yes. Mrs. Sousa was shocked to see in the body. He told you previously he didn't understand. He told you in this courtroom, when Phil Spector was, quote, drunk because he mumbled all the time, even though in the few times he had driven him, he'd never seen him drunk before. He told the cops he couldn't understand him when he's drunk and he mumbles. That's what he said, not us. Yet according to Mr. Sousa, Phil Spector, you heard the testimony, clearly drunk that evening. He admitted he had a language problem. English as a second language affects the comprehension of a person in a highly stressful situation. Even 4 years later, he mixes up his pronouns. Remember back, you'll look at that and others. Yes, she had like a briefcase, like a leather bag. She has it's like a brown light briefcase. He was Mr. Spector's briefcase. What was he wearing? He uses the word beige suit instead of jacket, a one-word mistake. It's female. I think it's like blonde hair instead of she's female. Another misuse of the word, because I opened his door and he got stuck in the door and he was looking to this guy. He looks like upset, talking about an alleged incident. He went to her car and we followed her until like a street closed to the parking structure. Rather than she went to her car. Oh, another misuse of the word. Ultimately, did you give Mr. Spector that valise? Yes. How did you give it to him? Did you place it inside the house? Yes, I gave it to him on the chair. Again, using the word beige suit for a white jacket. From his transcript, sir, basically each year you have to serve a little bit English in school rather than be taught. Take a little bit of English in school. At the end of 3 years, did you get any kind of certificate or did they give you a test to test your proficiency? No, I didn't make any tests instead of take any tests. I assume this is in response to a question Mr. Jackson asked you, that each time you told the officers about that incident, you wanted it to be accurate and complete. Is that correct? Yeah. If they're recording or saying to me that I'm recording, it's future. Yes, I'm doing that. Mix-up of the English. Well, November 2002, there was like the first job that I made for them. I think I made once a long time ago, a misuse of the English. Yeah, he didn't like me. He was upset with me. Misuse of the English. Volume 19.
Get it.
Yes, I remember that he said he was working like the whole night and needs a drink. Use the word he instead of she. Mr. Bruno asked him, could we get a transcript? All right, you see this here, Mr. and Mr. Sousa, when talking about the transcript, when I think you meant when he opened the door, But see, he said when she opened the door. So, ladies and gentlemen, when you look at this quote here, can you be sure? Would the coroner's investigators like to know that Mr. De Sousa said on day one that he had a problem with his English and he wasn't sure? Would you have liked to know whether he mixes up his pronouns before you accepted and bought into his story and called Phil Spector a murderer? Your Honor, would this be a good place to break? I have
How much more?
about an hour.
All right, I only have to see counsel afterwards. Keep in mind the admonition, ladies and gentlemen. We'll see you tomorrow morning at 9 o'clock. Thank you. 9 o'clock tomorrow morning.
We're getting there, y'all. We're getting there.
Inquiring if Ms. Kenny Bodden takes an hour tomorrow and we start at 9. Is that enough time for you to finish tomorrow?
Tomorrow?
Yes, Mr. Dixon?
Oh, yeah.
Okay. Am I going to have I need about 30 to 40 minutes to instruct. Am I going to have enough time to instruct?
I think so.
Okay. We'll see. All right.
So there's a couple. Kept morning. I can budget tomorrow morning.
I want to Kathy wants to know correction about is we consider it fabrication or suppression, I guess.
Correct. Fabrication of evidence, manipulating the crime
Okay.
scene.
All right.
Alternative B.
Yes, that's the one we're giving, but I just wanted to make sure before I handed it down. I need to ask you, it has to do with it has to do with one of the defense special instructions. It has to do with the personally used a firearm. It's sort of your theory, and I know we've discussed it about how Mr. Spector is responsible under your theory of the case, and did he actually place the gun in her mouth? Is it are there other possibilities? Can you give me some indications? That has to do with how these instructions are worded.
Well, the way that I've argued it, the way that I argued it yesterday, and I would just stay consistent with this, is our theory of the case is that he had control of the gun, that he knowingly and intentionally pointed it at her face, that through that conduct of pointing it at her, it ended up in her mouth. Whether, I mean, there's no way of knowing whether he said, open your mouth, or she screamed and the gun ended up in her mouth, or she began to talk and the gun ended up in her mouth, or if she was just frightened and it ended up in her mouth. But his hand was on that gun when it ended up in her mouth and went off.
Okay.
And that's as detailed as I think we can get, and that's as detailed as we need to get for purposes of second degree.
That's all I'm asking.
Okay.
The personal use of a firearm, the way it had been submitted, someone personally uses a firearm if he intentionally fires the firearm. Now, the question is, there's other alternatives where that use is still acceptable, which also includes displaying it in a menacing manner. Are you want in or out on that? Okay.
Yes.
Okay.
I think, again, consistently, we don't have to.
Okay. Now, the defense has submitted certain supplemental, now they're, as they're going by numbering, the which is their pinpoint instruction. About causing Ms. Clarkson's death. And again, Mr. Reardon, we're back to the problem. I don't know if you're aware of what my problem with this instruction and all its variations is, and that's why I asked Mr. Jackson and Mr. Dixon what their theory was. They're not saying that and under the law, they're right, that he placed the gun in her mouth, and therefore this instruction is an incorrect statement of the law.
Well, Your Honor, could I respond?
You may.
Your Honor, between once an accusation is made in a case and a theory is presented. In opening, Mr. Jackson said he placed this gun in her mouth. As a result of that, Your Honor, you made a critical ruling where it was the evidence is that this gun was so deep in her mouth that even if it's not even someone's mouth, it was that. We agree. The prosecution's theory is that he puts the gun in the mouth and it goes off. That's second-degree murder. If the prosecution's theory for the first time, they've never articulated this before, is that Mr. Spector was not responsible for inserting that gun in her mouth, we have a whole different panoply of because they're very clear in that regard. They promised this, they stated that that was their theory. They have never said that this was a case where he brandished the gun outside of her mouth and then somehow it went off. If that was the case, you'd be instructing on lessers. So I'm just now following what Mr. Jackson said. If they want to say that he caught the act that caused the death, well, I hear there has to be an act. We're entitled to know the act that certainly at this hour. I hear is that the act that he committed was putting the gun in her mouth. And we agree that if they prove that, they have, there are no other questions in terms of the second-degree murder. But if they're going to the jury on the theory that unlike their opening, he is responsible for her death without inserting this gun in their mouth, we are back to reopening the whole can of proof.
Well, and maybe no. Brandishing, I with you, we have a whole different gun in someone's face brandishing. That goes beyond brandishing. I'm just saying we have to find out specifically what they're going to argue, and that's why I need to know that. But that is not merely brandishing. But go ahead.
Your Honor, I don't know where Mr. is getting, it sounds like they're having second thoughts. They didn't like the way that the law reads. They didn't like the way that the arguments come out. Now they're having second thoughts and they're trying to figure this in. Mr. Reardon and I never had a conversation about how it's off with respect to the gun. So that's coming out of thin air. I don't know what he's talking about. Mr. Reardon has either, I would hope that he's gotten up to speed on what the theory of our liability is.
Let's get by the deepness that the gun. Let's just talk about what exactly.
Judge, my point is, can I just...
Yes, you may.
The theory is, I don't know how else to articulate it more clearly, I guess, is that Philip Spector pointed that loaded weapon, knowingly and intentionally, at her face, at the most vulnerable part.
Good gravy. Stupid thing. Stop it.
Part of her body, the face, the brain, that menacing at her face intentionally. The tip of it, behind the front sight, gets inside her mouth.
All right, StreamYard. I about had it. Between you and Court TV, I have just about had enough.
Malice is pointing the weapon, or pointing the weapon, or pointing the weapon in her face. That's our theory.
Okay.
Expressly argued in opening, and I will give
They're not bound by their opening statement.
Okay.
That's clear.
The basis on which we agreed that there would not be lesser included is that the insertion of a gun in someone's mouth is so clearly not only an act dangerous to human life, but one that any human being would know involves a conscious disregard for you, intoxication or lack of mental state, and the defendant testifying to that.
I'm starting to think we're not going to get this trial done. We are so close to the end.
The people have never, until closing argument, never articulated a theory that this gun was held outside of Mrs. If
The
that
way
is,
they talk about it when we had our conference before the argument, because that's where talk about the variations, possibility of what secondary consists of. Take the theory forward.
but Your Honor, if someone holds a gun outside,
It's not applicable. We talked about the law yesterday, and that's not applicable because there's an intervening event, which ends up being a superseding event.
but if they did that and the gun somehow went off, it would be a question of fact for the jury whether someone in that instance had a conscious disability, did a highly negligently. The reason why this is clearly a second or nothing is that the prosecution's theory is that the gun was placed that meets the definition. Mr. Spector committed it, which he contends he did not. But the contention that the act is simply putting it in front of someone's face as opposed to the theory that it was placed in the mouth, then raises questions. Then there'd be questions of fact for the jury about whether the implied malice, the conscious disregard for life, as opposed to gross negligence was present. We believe they're not in the case because we believe that this has always been a case is that he put the gun in the mouth or he didn't.
Okay. Well, if you want to find some case that would support that as a matter of law, that I have to give it if they go with the theory that it was in front of her face, either he pointed it in her face and it ended up in her mouth, or he placed it in her mouth, that with either one of those theories, and you're primarily concerned with the first, that you are then possibly entitled to lesser included, you let me know. You find the case. Because that to me is an assault with a deadly weapon. I agree with you. If all you have is brandishing, brandishing gets you anywhere from second-degree murder all the way down to misdemeanor manslaughter because of the nature of the act of brandishing. But what Mr. Jackson and Mr. Dixon are describing is an assault with a deadly weapon, which is inherently dangerous. Placing a gun in front of somebody's face, that's inherently dangerous. Okay? So the question is, if you want to get around the malice argument, find me a case.
No, I don't. We don't want to get around the malice argument.
Okay.
But I think we may be able to clarify this, Your Honor, because I think Mr. Jackson said that somehow the gun, and they're not saying it's an intentional issue, but I think their theory is that he is responsible for getting the gun into her mouth. Well, if they find that gun enters her mouth with his finger on the trigger, then essentially we agree that it's second-degree murder, but the government would have the burden of proving their fact, the essential fact they'd have to prove is that that gun is in her mouth with his finger on the trigger.
Okay. At the case, the facts that you've set forth in instruction do not set forth all the theories. So I'm going to refuse it. You can keep trying. I'm not precluding you. You're running out of, you're running short on time is the only thing.
I understand. Well, we will respond to it as quickly as it develops.
All right. Supplemental defense instruction 2. reads as follows.
I apologize for the depose.
I don't care about that. If you find that the investigators or experts from the prosecution lost or mishandled evidence, you may consider that fact in evaluating whether the defendant had a full and fair opportunity.
Judge, I don't know what the basis for the
Evidence is lost in case.
right, and if there's any evidence it has affected their case. If there was some evidence that it has affected.
I'm sorry, did I? Did someone just?
That was me chuckling because they haven't shown prejudice on either Henry Lee or Baden, and it
Okay.
just
We'll set aside the chuckle momentarily.
Well, the
Okay.
one thing that the court did ask and made sure of is that there was testimony from Dr. Harold concerning what effect that missing piece of evidence from Dr. Henry Lee could have or might have had on analysis evidence. There has not been the concomitant or the associated effect on the other side. I mean, they had the photographs. I guess I'm confused about what they're saying.
Well, what they're saying is we were deprived of some evidence because, if you will, carelessness of the investigation. We don't know what we could have analyzed. It did happen. It's an important instruction. It's just saying they lost something. You're free to argue. Mr. Dixon has the final argument. Has finished as to whether there's any, it's there.
Right.
It's basically. Also, one working, that means the box at the top. You have to use the right form.
Dadgummit, what are you doing?
Okay, I'm listening.
She told the judge 1 more hour. But there's 2 more parts to her closing. Oh, wait a minute.
All right, the record will reflect the jurors and the alternates are now present, and thank you for your patience, ladies and gentlemen. We're trying to resolve all the legal issues and jury issues. So that when argument is finished, whether it's within enough time today for me to instruct you at the end of the day or first thing.
So we get a break from her voice.
The record will reflect that the counsel for both sides are present. Mr. Spector is absent. Pursuant to 977. There's some matters we need to take up before I get into the record will reflect that the counsel for both sides are present. Mr. Spector is absent. Pursuant to 977. Before I get into there are some matters we need to take up before I get into legal matters. I want to talk a little bit about an inquiry that's been made through the court information officer, Mr. Pericchini, to me concerning whether admonitions to witnesses yes, it is. Until there is a verdict, if there is in this case, then the admonition to witnesses remains. If there is a verdict, then that admonition will be lifted. If, for any reason, although I don't think any is my intention, to continue the order, not only to witnesses, but potential witnesses, and we'll figure who will potential witness or witness before me to do that. What we've done in the past is both sides admirably have discussed it with their respective witnesses or potential witnesses and instructed them that they're under an obligation not to discuss their testimony or potential testimony. And right now, that admonition, which is a standard admonition on all trials, will continue until I lift it. And again, if there's a verdict, it will be lifted, and if there's not, we'll concern ourselves at that time. Now, we have an additional problem, and that's been brought to my attention today, and I'm going to make this statement, and I hope that everybody who it applies to is listening to it. I don't like gag orders. I've never imposed a formal gag order in my life. Other than the normal and customary witness admonition, that's all I do. If the attorneys wish to talk to the press, they can, though I admonish them. I would prefer that they not, and that the case be tried in the courtroom, and that applies to all participants. And the participants in this trial have been exemplary, and other than basic passing comments on occasion, which are, in my mind, perfectly simply self-imposed, my request, or taken my request and made it a manner of conduct for them. When I say the participants who are going to decide that they want to serve as surrogates and basically get an individual's position out to the press, then I'm going to reconsider my normal feeling about gag orders. And everybody who's seated here knows exactly who I'm talking about. I've discussed the matter with counsel. I'm going to leave it at that for right now. But I'm getting a little tired of people giving interviews and attempting, hopefully, in my mind, to do nothing but to sway the jury, even though they're under an admonition not to watch television or read news reports about this case. There is always the danger that it might happen. And I think, and I'm not, this is not directed to any attorney, not for a minute. This is directed to some individuals who are not using common sense. And if they don't have the self-discipline to use common sense, then I will take appropriate action. And I think that's all that I need to say. All right? Thank you very much. Now, let's talk about, we left off yesterday talking about whether there's any evidence and exactly what that might in some way mandate the giving of some lesser instructions. And just so Mr. Spector is not present, I think I've stated what the law is, just to make it clear. The theory have been both sides. Both sides have pretty up to this point agreed or stipulated that the only appropriate instruction is that of second-degree murder, no less. As I believe I've made clear, and if I have not, I'm not bound by that. If the evidence suggests, whether or not the parties don't want me to give lessers, if there is a reasonable suggestion by the evidence that lessers be given, if there's some substantial evidence, reasonable evidence that the jury can consider, it doesn't make any difference what the parties or I think about it. It's whether there's something that they should consider. At this point, I haven't heard. I think that's agreement. Basically, the question is whether there's any evidence that would suggest, other than a disregard, the instructions for second-degree murder set forth in Cal Crim specific language. And it would be with basically under implied malice that he deliberately acted with conscious disregard for human life. Now, the theory is obviously if the gun was placed directly in the mouth, there is no possible theory that I can see that it's other than conscious disregard for human life. You couldn't come to any brandishing or anything else. The people's theory, as I understand it, and basically has been presented through the evidence that I'm allowing under 1101B, which is that Mr. Spector acted in accordance with motive, which is that when faced with a certain situation, he emotionally responds by placing a gun to somebody. There's been no he ever placed it in the mouth. That's not necessarily placing it at the side of the head along with certain threats. In my view, and I'm willing to hear what you have to say, as long as the people keep the evidence to a gun pointed at the head, okay, then there is no other theory that's applicable. If it ever gets away where the gun is waving in the air, which becomes a brandishing, that opens up involuntary manslaughter. So I think what it depends upon, because this had to do with your pinpoint instruction, Mr. Reardon, that you submitted to the court, and why I did not accept it, because you kept saying gun in the mouth. It doesn't have to be gun in the mouth, but it can't get off track to where it's something other than an act, which is basically an assault with a deadly weapon, which is an inherently dangerous felony. And it depends on what they argue. And I'm putting the people on notice. If your argument goes off track, then we have a different situation, and the court's going to have to deal with it. Mr. Reardon.
Yes, Your Honor, and a discussion and it'll shape the renewed request for a pinpoint instruction. Your Honor, I could not agree more with the court that this is a case where lesser includeds are not required and not justified. People's theory throughout the case has been that caused the death of Miss Clarkson. The act, there's no question that the evidence here establishes what the act was that caused the death of Miss Clarkson. The act that caused the death of Miss Clarkson was a shot being fired from a pistol which was in her mouth. No one could possibly say that any other act caused the death. It was an intraoral wound that caused the death. And the people's position has been very explicitly that Mr. Spector placed that gun and shot her. And all we were trying to do with our Sears instruction, our pinpoint instruction, which we're entitled to, was say that this is a case where we're not contesting intent, we're not claiming alibi, we're claiming that he did not do the act that caused the death of Miss Clarkson. So the initial request that I made was that the people's contention is that he placed the gun in the mouth and shot her, because I lifted those words from Mr. Jackson's opening argument. I didn't think that was controversial, and that's our point. The government came back and said, well, wait a minute, I believe use of the word shoot would make it sound like it has to be an intentional firing. And there's evidence in this case from experts that she could have slapped at the gun, or even if he put the gun in the mouth and it went off accidentally, that would be second-degree murder, and therefore the instruction that you're giving unfairly limits our option of Justice Reyes. And I said, I agree with that. Okay. Let us remove any language which would suggest that you have to prove an intentional shooting, as opposed to a slap, an accident once the gun is in there. So my second supplemental instruction, which I stated, was the people's contention is that he placed the gun in the mouth of Lana Clarkson, and if they prove that beyond a reasonable doubt, it's going to be a second-degree murder. If they don't prove that beyond a reasonable doubt, the placing of the gun, then there has to be an acquittal. As I understand it, Your Honor, what the people objected to then was the notion that even the placing has to be intentional. And if he were to point the gun at her mouth and the gun were to go in accidentally, that would serve as a sufficient actus reus, because if you point at somebody's a gun at somebody's mouth and it goes into their mouth, I mean, the act of pointing it at their mouth, bear the consequences, goes off. And I agree with that. I think that's a fair position. I think that they can argue. Therefore, our pinpoint instruction now is that...
Which one are you referring to?
Well, I'm about to... I've handed this to...
I don't have it yet. Okay.
Yeah, I handed this to the prosecution. I'll hand it to the court. And this is an attempt to conform to the theory that the prosecution offers and is entitled to offer. And as I understand it, it is the prosecution's contention that the act committed by the defendant that caused the death of Miss Clarkson was his pointing a pistol at her, resulting in that pistol entering Miss Clarkson's mouth while in Mr. Spector's hand. So this is fine. The defense theory is that he did not point a pistol at her and not pointed at her mouth. If they prove that he pointed a pistol at her mouth, the pistol entered her mouth while in his hand and went off, then they prove second-degree murder. I would think that the only objection to this instruction would be, no, actually, it is our theory that if he pointed the pistol at her, he is guilty of murder, even if she put the gun in the mouth, and shot herself. So if he pointed a pistol at her and she wrested the pistol away, put the gun in her mouth, and shot herself, either intentionally or unintentionally, he is guilty of murder if his hand is not even on that gun. And on that, Your Honor, the people are not entitled to argue that theory. They are not entitled to argue that theory not because if they had started with that theory before the case began and ran and rested this case on a very complicated proximate cause theory, that they might not be able to make out a theory of murder. But what is absolutely true is that a defendant is entitled to know the act which he is alleged to have committed before trial, certainly before closing argument. And if the people were to get up in closing and say, well, the defense has made a very big deal of the fact that he wasn't standing in front of her and couldn't have had his gun on the hand on the gun. She could have had her hand on the gun. Well, we can even convict them if we embrace their theory, because if he did as much as arrest it away and shoots herself, he's still guilty of murder. That would raise the most profound constitutional objection. Under Cole versus Arkansas, there would have been no due process notice of the theory. It wouldn't have been injected into the case. It would have been articulated for the prosecution. But point to a point where they've articulated that in closing argument. And furthermore, it would necessitate, then, if they had that theory, you'd be into a complicated theory where you'd have to give proximate cause instructions, because there are two causes, and was the brandishing or the pointing the proximate cause of what happened with Miss Clarkson shooting herself. The court quite correctly says this is an approximate cause case because we know the cause. This isn't multiple causes or one event cause another. So the only objection that people could have to this is that they want for the first time to argue that even if Mr. on that gun when it was in Ms. Clarkson's mouth is the immediate cause of death, he can be found liable on some protracted liability of proximate cause liability that has never been suggested. That the court, at this point, of course, the court can't change an instruction to add proximate cause because it has to give those kinds of instructions or settle them before the arguments begin. So we would submit that this is an instruction that stretches the prosecution's theory of liability to encompass everything that they could possibly want, unless they want to argue an impermissible theory that Mr. Spector could be convicted of murder even if Ms. Clarkson pulled the trigger.
Thank you. Mr. Dixon and Mr. Jackson.
Your Honor, may I say something?
Yes.
What counsel has just argued was I don't have a big objection to this, the exception clause. But I think that's beginning. If the court were to take its pen and end at hand, I think that is an accurate statement of the law. It would read, it's the prosecution's contention that the act committed by the defendant that caused the death of Ms. Clarkson was his pointing actually it's not a pistol, it's a gun, at her, or at her head and face, or head or face, something like that. There's no requirement that we prove that he put the gun in her mouth. That's the part that's not an accurate statement of the law, and I would submit to.
I think that's been taken out. That was the objection that I basically. I kept denying them their pinpoint instruction because I agreed with you that wasn't the law, that he didn't have to place it in her mouth, and I'm asking where that appears in this instruction.
Unless I have a different version, it reads, if the court reads the second full sentence, it reads, it is the prosecution's contention that the act committed by the defendant that caused the death of Ms. Clarkson was his pointing a pistol at her, resulting in that pistol entering Ms. Clarkson's mouth while in Mr. Spector's hand.
Right.
From resulting to hand is unnecessary. If you take it out and just read it and it ends at the word, the act that was committed was his pointing we could put loaded gun or however you want to put it, at her head or face. That's what we have to prove. That he pointed the gun at her head or face. That it was an intraoral shot is an aside. It could have been an eye socket.
I agree with in the abstract, what you're saying is absolutely,
okay.
But we have to the purpose of a pinpoint instruction when it's requested by the defense or even by the prosecution, if you would, is that it reflects the general law to the specific facts of the case. And here we know that the gun did enter her mouth.
Correct.
And you don't have to prove that he put it there. If she was resisting in some way and the gun ended up in her mouth, then he's liable. And I think that's what this instruction says.
Okay, then my only, if the court is, and like I said, I don't have strong objections to it. One, I guess it's a grammatical thing. I would suggest that, first of all, we change the word pistol to gun.
That's fine, Your Honor.
Okay. Just to be accurate, we've all called it a gun throughout the trial. I would suggest after her, is there a comma there?
There is a comma after her.
Okay, which resulted in that gun entering Ms. Clarkson's mouth while in Mr. Spector's hand.
Any objection to that? It doesn't change.
No objection.
It doesn't change anything just grammatically.
Okay.
It's more.
Just let me change it. Okay. All right. And as long as the people's argument basically
We expect
goes
it'll be tailored to this theory. I mean, that's what my argument and opening argument was. I expect this to.
let me hand it. If you made the changes, that's fine. We need an original and did we say 28 copies?
We've got all the.
Yes.
We've got all the instructions done at this point.
Okay.
There's-
Just do
I'll just
that.
add this to it, and I'll give it to you at lunch.
That's fine. You ready? Here we go. All right. Okay.
These are things that I don't think Mr. Dixon can clarify in rebuttal. I'm not going to sit here and argue about every misstatement of fact. That's what rebuttal's for. We'll take care of most of those. However, there were, I think, a couple of inappropriate statements or pieces of evidence suggested by Ms. Kinney Bodden during her closing, and there's 4 points. First, the defense was very quick to make sure that I wasn't in my closing argument making any personal attacks on the defense, and I couched and I think I defended myself accurately. I couched all of my comments insofar as I didn't comment on any defense attorney. I certainly didn't say that any wholesale attack on the defense. I was taken a little bit aback by the Daniel Stark clip that was played yesterday. That clip was played for one reason and one reason only, and that was a personal attack on me. Had absolutely no evidentiary value whatsoever. As a matter of fact, the court admonished the jurors that comments made by the lawyers, they are not evidence. The only way that they become evidence is if in fact it gives context to an answer. Well, the clip that was played by Ms. Kinney Bodden was, may I explain my answer, coming from Mr. Stark, which would have been evidence. That's fine. Then she played me saying, no, I didn't ask you a question. If it needs to be cleared up, you can clear it up through Mr. Rosen. And then Mr. Rosen stands up and says, clear it up. And then the clip stopped. Right. The clip was brought into evidence to attack me, not for the evidence from Daniel Stark. And Ms. Kinney Bodden followed up by saying, you can see from this that the government treats witnesses, quote, with malice and contempt. The government is desperate to tear down the character of witnesses. And if you trade the word government, that's a real nice broad term that has become
well, there's only two representatives of the government.
There you go. It's me or it's him.
Branch, but I'm not myself.
Call Mr. Dixon and myself the government, but if you were to trade that for instance, if I were to trade that with the defense attorney and say the defense attorney treats witnesses with malice and contempt, you would have stopped me. I think that's an unfair attack on me for vigorously cross-examining some or all of the witnesses that I cross-examined. I just don't think it's fair. What's good for the goose is good for the gander. I didn't attack defense counsel, and I'd appreciate it if defense counsel showed us the same respect and did not call me personally malicious or contemptuous. I thought that was inappropriate. Number two, the bureau drawer, and giving Ms. Kinney Bodden credit and all due deference, she wasn't at the jury view. She said yesterday that the drawer may have been stuck open. Therefore, Lana Clarkson may have seen the gun as the drawer was stuck open. We don't know. Well, actually, we do know, and she wasn't at the jury view. We were. The court actually asked us, and Mr. Rosen, I think, physically did it, pulled that drawer open and closed it. And so the drawer was still open when the jurors saw it, but it was open because the court asked us to open it so it would approximate how the foyer was. It wasn't stuck open. I think that needs to be cleared up factually. And it was a matter of speculation, not significantly different from, and it was something that's not in the record, not significantly different from the tequila bottle that the court, I think, properly talked to me about and cleared up. The third point is the PEX exhibits. You know the back spatter exhibits that
Yes.
we've seen so much of? I objected vigorously to those being admitted into evidence. And my objection was they do not approximate the back spatter in this case. Mr. Plord, I believe it was Mr. Plord, argued, absolutely, they don't. And this is what you would expect to see on Mr. Spector's jacket. This is what the back spatter should have looked like. And that is exactly why I did not want those exhibits placed into evidence. That's not what the testimony was, and it's misleading to the jury. And the final point is a little bit more difficult and a knottier legal issue. K-N-O-T-T-Y. Ms. Kitty Bodden said that Ms. Clarkson could have been told by Mr. Spector about the gun in the house. That's something that Mr. Spector could have told her, that on the way home he could have said, hey, look, there's a gun in the house, and therefore she looked around and found the gun, or he placed the gun in the drawer and she saw that, et cetera, et cetera. There is one person in this courtroom that would know that. And he's sitting right there. And we can't, this is a point that Mr. Dixon, I don't believe, can address because we're getting too close to Griffin. Okay. The court has to take care. That was an absolutely pure speculative comment by Ms. Linda Kinney Bodden. It was inappropriate. There's no evidence of it. I would like the court to admonish the jurors there's absolutely no evidence that Mr. Spector ever told Lana Clarkson anything about a weapon or where the gun was or where it was secreted. If Mr. Dixon does it, we're going to get awfully close to Griffin.
I understand your concern, and I'll address that.
Okay.
Well, as long as we're doing this, there was one other statement, and I was real careful with the defense objections, and believe me, I've reviewed almost every case, and I did this before. Both sides argued, just to be ready, just to not expecting anything, and quite frankly, there hasn't been that many. Well within the bounds of normal argument, where occasionally something is crossed. I mean, I haven't heard, with very few exceptions, anything that might be a problem. But the ones that I was very careful to admonish the jury about as the defense, there was one that I think crossed over from acceptable comment to the same thing that I upheld for the defense, and that was a comment that the prosecution corrupted the evidence. And corrupted is a very strong and inappropriate word. If you want to say, misapplied or misinterpreted, that's fine. Corrupted is a very specific, and to me, if I'm going to do it for the defense, I'm going to do it for the prosecution, and I think that was a mistake. So I'm going to admonish them about that, unless you want to self-correct that, Ms. Kim. But it's up to you. Okay. Before I'm going to, but before you do that, I'm going to make some comments, because some of these can be taken care of by Mr. Dixon. The back spatter, as you say, there's evidence, and he said that's not. Just point out what the evidence is as to the Jack Pollock exhibits, if you will. Not that I want to be an art critic. Without attribution, thank you. But that you can cite the record to clear that up.
That's fine, Judge.
The other matters, I think we need to be discussed. So, Ms. Kinney Bodden, you can go ahead and tell me what you think.
Davis specifically testified that Mr. Spector told her he tells First Mason that he carries a gun. I'm working off an inference on that, and that's a legitimate inference because this is the first time he met Ms. Clarkson. And that was a testimony from Rami Davis on direct testimony from the state's case. And in fact, he told Rami Davis that he carries a gun in case they're upset.
so that people don't get upset. So I think that's an absolute legitimate inference. That's not saying that he's testifying. It's an inference from what Rami Davis said.
That's not the problem. What the prosecution is saying, it's a perfectly legitimate argument for you to make and to draw the inference. I don't have a problem with that. The problem the prosecution is stating is Griffin error. And for those that don't know what Griffin error is, that the prosecution is not allowed to either directly comment or infer anything that would interfere or comment upon it. Concerned about is if that's not supported by evidence, since the only person who could testify, Mr. Spector, and since he did.
I use the word inference.
I love this judge because he explains things. He explains his decisions. Griffin error. Most judges would just say Griffin error and just be done with it because lawyers know what that is. But for anyone who doesn't know what that is, I love this judge. I wish all judges would be this way because they know we're watching. But most of them don't care. Just because they don't like the camera being in the courtroom, they don't care. So they're not going to explain stuff. I love this judge. I especially like that he explains his decisions. Because sometimes, even when they do speaking objections, and we can hear, they say why they're objecting, and the judge will say sustained or overruled, but they don't explain why they came to that decision. Sometimes he will explain why he comes to the decisions he does, and it's so helpful because you understand what's going on. I love this judge. I wish he could be the judge for every case we watch. Which is totally unreasonable, but still, I want him to be the judge all the time.
I know what they're raising is a concern with me, and there's certainly the prosecution is allowed to make the following argument. It doesn't apply specifically to the facts of this case. There is no evidence to support that, and quite frankly, I don't think there would be Griffin error. That there's no evidence in the record to support that. If you stick to that, that's not Griffin error.
That's
Mr.
what
Reardon,
I
you want to
said.
be here? Because I don't think it is, because otherwise I'm going to have to get involved.
No, Your Honor. Let me be clear on one thing. There is absolute prosecution is going to get up and say Mr. Spector took a gun on that day, at the so forth and so on, and it's going to do that not based on any evidence that anyone observed that on that night. It's going to do that on that you can infer the acted that way as he had on prior cases.
I agree that that's an inference that the defense is allowed to draw and to comment upon. The question is, how does the prosecution go about it?
Let me address that.
Okay.
I think it is perfectly appropriate to say that the defense has argued that Mr. Spector may have said this to Ms. Clarkson. It did that based on a claim that Davis said that he had made comments to her. Gentlemen of the jury, that is not a legitimate inference to draw from Ms. Davis's testimony. What they can't do, and true, Mr. Spector would have gotten on the stand.
I think we know that. I think it's fair to say that. That's a general, and that's what you're allowed to say. And that's what I no evidence to support that. I mean, I frankly, it's not Griffin error.
I understand my to it. That's why I thought the court's going to say, I would suggest the court tell the jurors that.
But I don't need to. What I'm saying is,
You have a problem with us.
absolutely. Mr. Reardon has just stipulated.
I didn't do it. I didn't touch anything. I don't know what happened. I think I know why they brought in Reardon. Because he's just here to muddy the waters. Cause confusion. He wouldn't even hear the whole trial. How do we even know that he knows what he's talking about? He hasn't been here. And he's going to come in and help with jury instructions? He's just confusing everybody. I don't know why Judge Fiddler even let him do it. Why? I didn't tell you to do that. I told you to share my screen. Do what I tell you to do, StreamYard.
You want me to clean it up a little bit and say there's a half story? I'll be happy to do that.
I do. And then we have to deal with the drawer. You can either do it yourself or I'll do it.
Well, the problem with the drawer is that I argued again an inference, Your Honor, because on the 4th in the afternoon, the
Didn't I say that wasn't in evidence? Did I not say she's wrong? There was no evidence of that. Did I not say that?
drawer was still open. So
You can argue that.
No, we don't know whether the drawer was stuck or not. And then 3 years later, we don't know what that bureau.
Well, that's perfectly reasonable, but leave the drawer open because the jurors may want to look into
talking
it.
about the jury view, though, Your Honor.
But I think there's that inference that it's possible. You can argue all the rest. That's perfectly acceptable.
Because I didn't know the jury.
I know.
To tell you the truth, until you just told me, I didn't even know the drawer was pulled open.
Well, just roll that into your argument.
Okay, I'll roll it in.
Thank you. Ladies and gentlemen, we're trying to resolve all the legal issues and jury issues so that when argument is finished, whether it's within enough time today for me to instruct you at the end of the day or first thing Monday morning, as the case may be, that we're ready to go without any further delay. But Ms. Kenny, by you.
Thank you, Your Honor. Good morning, ladies and gentlemen. I'd just like to go back and just clarify a couple things.
All right, the record will reflect the jurors and the alternates are now present, and thank you for your patience, ladies and gentlemen. We're trying to resolve all the legal issues and jury issues so that when argument is finished, whether it's within enough time today for me to instruct you at the end of the day or first thing Monday morning, as the case may be, that we're ready to go without any further delay. But I do thank you for your patience. And Ms. Kenny Biden, you may resume your argument.
Thank you, Your Honor. Good morning, ladies and gentlemen, I'd just like to go back and just clarify a couple things for yesterday in case you were left with the wrong impression, which we definitely don't want you to be. When we're talking as a representatives of Mr. Spector to you and talking about evidence being corrupted, we're not saying somebody falsified or phonied or anything like that. Certainly not the two prosecutors here. We're talking about an institutional view of things that doesn't give you the whole story or misuses or in some way misinterprets the evidence to support them. So I just want you to understand that so that you don't think that there's any personal attacks on these two fine gentlemen who are sitting here. The other that we're talking about, and I'll discuss Mr. Starr, that's what we're talking about, that we want you to look at the whole story, not look at one side as parties may have presented to you. And the third thing I wanted to clarify for you is, remember we discussed that drawer in the credenza about whether it could be stuck open on February 3rd because it was still open on February 4th and all the pictures at the end of the day when Mr. Spector is there. Now, I know you at the jury view apparently had the drawer open. What I was discussing with you had nothing to do with what you did at the jury view, so that we understand that we're talking way back in February 4th, 2003. So with just those little comments, I'd like to bring you back to where we ended off yesterday, and we ended off with Mr. DeSouza and some of the mistakes that he would make in the English language, which may be important for you to determine whether there is accuracy in the 1, 2, 3, or 5 words that he claims that he had heard. And the last one that we wanted to bring out to you with regard to, and it was in one of his transcript interviews, if we could, Mr. DeSouza is asked by Detective Tomlin how tall, it turns out it was Lana Clarkson was, and about how old is she, and Mr. DeSouza says, she's not new, rather than she's not young or she's not old or whatever. So again, one word makes a very important difference in this case, and you can see that there are claims or there are places where one word has been misused. Now, I'd like also go back briefly to 911 call just a little bit more. We had up yesterday, if you recall, the transcript prepared by the government, which had put quotations around the words, I think he, but in addition to whether or not it could be that Mr. DeSouza said, I think he said the following, it also could be another interpretation, and we asked you to look at this. The words I think he could refer to Mr. DeSouza's own opinion as to what he happened. Remember, this is in the transcript here, the first call that's made or second call that's made. Another reasonable end to that sentence is, I think he killed somebody. Why? Well, Mr. DeSouza, he hears a shot, he sees a body, and he hears Philip say something. And he naturally makes a simple association.
He hears a
and then
Poe?
that becomes his memory. An eyewitness and your witness memory, as you heard from some of the witnesses say, that's why we have science, because they're fallible. These are common mistakes, exacerbated situations. So I'd like to summarize for you some of the factors that could have affected Mr. DeSouza's ability to hear Mr. Spector's 5 words perfectly that night.
Didn't we already do this?
He was fatigued. We talked about that. He'd woken up from his sleep. We showed you the transcript on that. There was opera playing in the background, but opera is, as you know, arias and all. The fountain, which you heard. His shock at seeing a woman with blood around her. So these are factors, along with the fact, if you recall, that he also said he saw Philip Spector be white. And he told you Philip Spector's voice quality, that he'd had trouble understanding in the past. He said that Philip Spector had alcohol in him and couldn't understand him with alcohol, and also even Mr. Spector's exhaustion. So these are all different factors that also wind up, and when you're discussing whether someone's just merely mistaken about whether he accurately heard the 5 words he claimed that he did heard. And also, now when we remember that we have that at that point, once the government's mindset was that he had works, which they adopted, and you saw that they adopted right in those tapes, Mr. DeSouza, when he is in the police custody, we had a long talk here about immigration status. Mr. DeSouza knew what his status was, even if the police may not have known it at that particular moment. And we're not saying that he's a bad person because of this. In fact, for hardworking immigrants, there's a big movement, as we all know, that these laws should be changed and should. But irrespective of your political viewpoints on those laws, the government since 2003 has controlled his fate because they have known that he was an illegal immigrant. And his uncertainty, the South's uncertainty on the very first day has become a certainty when he came here to this court. And you have to ask yourselves, why? Is it because was in control of him, sending letters to the State Department saying he should be here? And interestingly enough, when you ask Mr. DeSouza whether he's sure about those 5 words that Mr. Spector says, if you go to a different area about his immigration status, he says you have to talk to his lawyer. Okay, now the question, do you feel that you owe something to the prosecution for some help they've given you? Answer, no. Question, they have given you some help though, haven't they? Answer, could you repeat that? Sorry. Question, they have given you some help, haven't they? Answer, I'm not say yes because you have to talk to my lawyer about that, okay? He knows everything. I don't know like that. So he's certain about Phil Spector, but on a very important issue to him, you have to talk to his lawyer about his immigration status. So these are all factors you have to take. Doesn't mean he's a person, but let's remember who was sending letters to try to help him to stay in this country when other also very hardworking don't have that advantage. Now, I've talked to you a little bit about the reasons why, based on the evidence on a reasonable doubt, that Adriano DeSouza is correct in his testimony about what Philip Spector said to him in the early morning hours of February 3rd, 2003. But my important point about this comes last, because it consists not only of my argument to you as to the facts, but rather of what Judge Fidler, and you'll hear it from him, and if I say anything that disagrees with him, trust me, okay, and hear it at that point, will tell you about the law. And these are unlike lawyers' arguments. Judge Fidler will tell you that you must consider with caution any evidence regarding a defendant's oral statements. The only evidence in this case that must be viewed with particular caution is the testimony of Mr. DeSouza as to what he thinks he heard Philip say. So the mountain that the prosecution must mount to prove any fact beyond a reasonable doubt, if anything, is higher as to Mr. DeSouza than any other witness, because his testimony bears a unique burden. You must view any testimony concerning an oral statement of a defendant with caution. Now, in addition to that, what Mr. DeSouza claims he is certain about is opposite to what he said and how he said Philip looked and reacted. He said that when he saw Philip coming out, Philip was white. He looked shocked. Clearly, the blood obviously had drained from his face. He was white. And when he asked Philip what happened, Philip answered in a verbal way the exact opposite of someone who was admitting to a crime. He said that Philip gave a shrug, his hands up, and the normal, I don't know position. I don't know. That is a statement of innocence. That is not a statement admitting guilt. The government has spoken at length about Philip's actions and behavior after the shooting and what they call consciousness of guilt. Now, if Philip was indeed feeling guilty, why would he have walked outside knowing somebody is there minutes after the shooting at all? Why would he go where he knows someone's there? And why would he supposedly confess? Rather, we know that he got a diaper, which Mr. Jackson told you in his opening statement was in the bathroom, and which we don't dispute. Several of these security diapers, one of them was downstairs in a bathroom, and I want you to visualize. And we don't dispute that. What we dispute is what he did with
What is his real first name, Judy? I thought it was Philip.
the diaper. The inference, you can't draw an inference because it's somebody's face was wiped that somebody was trying to hide evidence, especially if Lana Clarkson had been breathing, and even if she hadn't, to try to figure, is something happened? Is she shot? Is she shot here? In fact, if he hadn't tried to help her, I would imagine that the government would be calling him all sorts of names. He used the diaper, the inferences, to wipe her face, wipe down her face. The little word creates a sinister connotation. And you can look at the evidence in both ways. And you'll hear later on we discuss how you look at the evidence. If there is a fact that points to innocence and a fact that
His name is Harvey? Like the rabbit?
points to guilt on a circumstantial evidence case, you must go with the way that points to innocence. And we'll discuss that further a little down the line. Going back, we know the baby, and the diaper is not washed off because there's clotted blood on top of it. And the pictures in there, you'll see it. And what's the significance of this? That means the diaper wasn't washed off. It wasn't put in the toilet bowl and washed off, or else the blood clots, the coagulates simply would not lay on top of the diaper. Rather, it supports the fact that Philip went to the bathroom, put the diaper under the faucet, wet it, wiped her blood. You see a diluted blood on the diaper, and Lynn Harrell testified to that. And also when he got some of the clotted coagulant on the blood, and therefore he was not hiding it. And you heard that it doesn't take 15 minutes here just for blood to clot in a wound, a head wound, that some of the blood comes out as clotted coagulant, and in fact, this diaper had tissue in the clots. So you don't need to wait 15 minutes. That's what happens in an intraoral gunshot wound because you're getting tissue from certain areas of the face and the brain. Now, after trying that, what's the inference? That Philip tries to hide? No, the inference is that he goes outside, and the inference is because there's some blood on the doorknob, which were separate. And that means you didn't try to wipe anything away because you've transferred what you've just gotten from trying to help somebody onto the outside where you know somebody is standing, not to try to hide anything. There was no wiping down of any door latch or doorknob, or even perhaps a door lock notch and door lock. And they're separated from each other. Remember that. And he's right-handed. And he goes out, and he goes out, and he goes out right to Adriana D'Souza, who he knows is outside. Ladies and gentlemen, I submit to you that the inference here is that this is Phil Spector's call for help to the person he knows is outside. Philip speaks to D'Souza, whatever the words are. He speaks to D'Souza. And remember, D'Souza says that he run down the driveway with a phone. He doesn't know how to use it, a cell phone. He doesn't say Philip turned around and ran away. What's the inference? Philip was watching him run down the driveway with a cell phone. And then D'Souza tells you he comes back to the car because he forgot he had the car. And he gets in the car. He doesn't tell you Philip walked away. What's the inference? Philip sees D'Souza driving away. The inference is to get help. To get help. Not to have some type of sinister act of covering up a crime scene. And that is the evidence. That's two ways to look at the evidence. But that inference was never looked at by the government. because they only had an institutional mindset that somehow he tried to cover up evidence. Now, DeSouza said he saw Philip come out with a gun in his right hand, which would make it impossible, obviously, to open those two door latches if you're using two hands. And if he has it in his right hand, how is he opening, when he's right-handed, the door latch and the doorknob? Is he going to use his left hand? It doesn't make any sense. And for the first time at trial, he says he sees a brown grip of the gun handle. Now, you saw when Mr. Brunon had that small revolver, you couldn't see the brown handle. And he had never, in all of his interviews, any of his statements, before he got here to trial. And you can't see it. But you can see the grip of the handle if you've looked in and seen a gun at the foot of Lana Clarkson. That you can see. And what Mrs. Sousa did is what other witnesses do after history. He transposes the gun into Philip's hands because he sees a gun and he thinks somehow that Philip has shot this woman. Transfer that gun. It's like just correlation. It's not lying. It's just filling in the facts where you think they should be in a stressful situation. Or he sees Philip with the balled up diaper and he thinks it's the gun. And that's exactly that washcloth, pictures of it in the bathroom. It's all kind of balled up. It's not large and stretched out. Moreover, Phil Spector clearly was on the gun because there are fingerprint ridges that you saw yesterday. And again, when they look at this, on the gun underneath blood, not on top of blood. Not on top of a long spatter that you yourself would be able to see. All this is very normal, in the face of the science that says Philip Spector wasn't trying to clean anything up and wasn't going to hunt, wasn't holding a gun. And you can go in your search for the truth and see what you see. By the way, let's talk again at this point, whatever happened to Mr. DeSousa's uncertainty that he expressed about those words. Again, no one learned about it. We discussed yesterday that Coroner Investigator Nelson said you have to challenge and verify, and that it would have been important for her to know about these statements at time of trial. Dr. Pena sat here for 5 days, and he was given police reports, and he told you that the first and foremost reason Dr. Pena told you that he called this a homicide was because Philip Spector had made a statement to Adriana DeSouza. That was his reason, not something from the autopsy table. Well, if you're going to rely on that as your reason, you should know at the time that he also made a statement that Mr. DeSouza was uncertain whether he heard those words. And Dr. Pena said once he got here at trial, he was not going to change his opinion that this was a homicide. He told you that. But he didn't know about those words at the time that he expressed this was a homicide in the death certificate, and that was still his main reason. He never took into account any uncertainty. Dr. Pena also said it was very important that there was blood in one of the front pockets of Philip Spector. But search your notes. He never told you why that was important. Had there been some type of implication that Philip put a gun in his pocket? What did it mean? It's consistent with innocence that Philip did not wipe off his hands, try to hide evidence, wash his clothes, not consistent with guilt. It got there because Philip Spector didn't wash his hands. That is a circumstantial fact that points to innocence. Was it also transferred to the banister when he went to the bathroom to put the diaper back? That blood wiped off the banister. Nothing was wiped off or wiped down. Nothing was destroyed. Everything was in plain view. It was kept there, ladies and gentlemen, I submit to you, because he knew the police were coming, because when he went outside, he saw Mr. DeSouza use the phone and leave. Let's discuss one further reason why Philip Spector would not have come out holding the gun. DeSalza says he hears a Poe, and he walks around, goes to the air conditioner, the trees, the fountain. A couple minutes later, goes to his car, and then sits in his car for a minute. What is that? 2, 3, 4, maybe 5 minutes after hearing the Poe? The government, in their closing yesterday, tried to say that the time frame was about 20 seconds to a minute at most. You recall that Mr. Jackson indicated it takes about 20 seconds to walk around the fountain, a minute in the car. I suggest to you the reason that they're trying to now limit that time frame is because they know that Philip went to the bathroom, got the diaper, and tried to help Lana Clarkson to see if I could help her. By shortening that time frame, that's impossible. But here's what Mr. DeSalza said in one of his interviews. So from the time you heard the sound until the door opened, that was what? 4 minutes? 5 minutes? Something like that? Answer: about 2 or 3 minutes. The reporter, I couldn't hear. Question by Mr. Brunon again. Is it 2, 3 minutes looking around and then a minute or 2 in the car? Is that our time frame? Answer: yes. That's about 5 minutes, not 20 seconds to 1 minute. That's about 5 minutes. And no one who has just shot somebody holds a gun in their hand for 5 minutes, walking around, and then comes outside and allegedly confesses. It doesn't make any sense. What makes sense is that he tried to help Ms. Clarkson first, then came outside. Not that he came outside holding a gun. The scenario that it's only 20 seconds to a minute ignores the state's own witness, who said this under oath, and you don't have to take my word for it, black and white. Again, the blood on the diaper had coagulated, and an inch or comes, it all together. That's what not his stories. Government has a lot invested in Mr. DeSalza, and you have to believe his statement. Because the science...
Apparently in Brazil, pal is pronounced po.
Science does not support their case. They try to buttress DeSalza's testimony by Phil Spector that hinted to you, cleaned up for 40 minutes, and therefore this consciousness of guilt tells you DeSalza must have been telling the truth. But no police officer came in and told you that something had been cleaned up. Mr. Kyle told you everything was there for them to see. It was all in the open for you to see in the pictures. And what you didn't hear also, that when in the initial consciousness, when we brought the Alhambra police officer here to talk to you, and again, we standing on that second floor landing, and you've been to the house right at the stairway, and he had his back on the window, and then stairs. Obviously, he came downstairs because he saw them and went right to the front door. Obviously, because he saw them. And to the officers who do not have a language problem, do not misuse words, we had to bring you the officer to say, Mr. Spector, Philip said, you have to come and see this. You have to come in and see this. You have to come in and see this. You've got to come in and see this. Officer Alhambra Police Department. Okay? And in any event, they decide that because they already have a murder suspect and he does not keep his hands out of his pockets, he puts them up. Look, you got to come in and see this. Got to come and see this. They're going to tackle him and seize him. Now, we're not castigating the officers because that's a different issue, an issue for a different day, a different matter. However, we are casting the government's use of this. We are suggesting that the government's use of this allegation that he did not cooperate as a consciousness of guilt, that somehow he resisted arrest, is false. Mr. Spector invited them in as if he was waiting for them. Just as someone who thought the Sousa had gone for help would expect that the cops are coming, leave everything where it is. So come, he's not staying down there in the hallway with a deceased woman. He stays up he's gone up to his bedroom, if indeed he has, taken the jacket, stays on the landing, keeps everything, and as soon as they come, he comes downstairs and tells them to come on in. That is not the actions. Those are not the actions of somebody who thinks he's guilty. The government's had a guilty mind and an evil heart, but he was waiting for the police and invited him in. A guilty person simply does not do that. And what you also heard, if you listen carefully, is that the front door had never been closed after the Sousa left. Because what the officer Hammond didn't tell you is that Philip opened the front door. He just said he came out. He came out. When they got there, they saw a body and he came out. That's the reason why you know it's still open. And why is that important? Because Mr. Jackson told you in opening statement about the actions that Philip took after the shooting indicated this consciousness of guilt. He told you that Phil Spector spent 40 minutes inside the house covering up, cleaning, making up a story. The question for you is, why would Philip supposedly cover his crime with the door wide open? It's like, back home I would say it was like committing a crime in Giant Stadium, but I guess you have, Dodger Stadium out here, Rams, whatever it is. I'm not a sports person, as you can tell. But whatever, you don't do it. You're not leaving people to see what you do. And that's very important. There is no consciousness of the area. The select past relationships, the select past relationships that were brought into this courtroom from 10, 20, 30 years ago. I'll discuss with you now those 5 women who supposedly supply a motive for Phil Spector to kill Lana Clarkson, but in reality have nothing to do with this case at all. And like all tall tales, they grow and grow. The government wants you to believe that these alleged incidents prove that Phil Spector had a motive to kill somebody he only met a couple hours before. All of the women here had long-term relationships with Phil Spector. All of them. They knew him for a long time. Some of them even continued the relationships after the supposed allegations that were testified to. One of the things we also know from these women is that there's a period of time with Philip where he spends time being charming, romantic, thoughtful, according to all the women. That doesn't fit the psychological profile of somebody who would just kill somebody the first time he met her. Not the same. Dorothy Melvin comes in here and says she was battered on the head, hit twice, if I recall, and you'll use your recollections, with a gun on July 3rd, 1993. That she was bloodied, all to see. That's untrue. And how did you have to find that out? Well, we were the ones that cross-examined an officer from the Pasadena Police Department who contradicted her claims, which were first made in this courtroom. According to him, she had no bumps on her head. She desired no prosecution. Her purse claimed you in the living room where she'd claimed Spector had stolen it or hidden it. The officer, despite what Melvin said Philip was not drunk. Moreover, the officer told you, this 20-year veteran, police force, that not only would he have to, but he was obligated to have conducted a further investigation if he had seen any indications of violence. Ms. Melvin then says she dated Phil Spector or had a relationship with him thereafter only 2 to 4 times in public places. Remember, supposedly this occurs. And yet, according to her friend, Mr. Tenazzo, who suddenly appeared in this case near the beginning of the trial, no police reports on anything, and there's no notations of anything before. Supposedly, Phil was invited as Dorothy Velman's guest to 2 Joan Rivers parties, one in December 1993 and in December 1994. And the last time he saw Phil Spector and Dorothy Melvin, they were driving away together in a car. Now, that is supposedly after he battered and bruised her with a gun on his head. She also emails jokes to him. She was emailing him and had an email relationship with him until January 2003, just a few days before this incident that Philip Spector is charged with happened. Clearly, ladies and gentlemen, whatever happened in 1993, whatever happened, it was not a life-threatening incident. And clearly, it had nothing to do with what happened later in February 2003, 10 years later. Melissa Pelagi Grosvenor. The government then brings to you, Melissa Pelagi Grosvenor, a convicted felon for bank embezzlement to discuss another alleged incident. Keep in your mind, Ms. Grosvenor was the only person that testified in this courtroom that was convicted of a crime involving dishonesty, convicted of any crime. Initially, she told you for all of her testimony until almost the very last questions on, I think it was recross, that this incident that she had allegedly occurred in December 1992. Of course, there's no police reports, there's no other statements, there's no nothing to go back and check any of that out. But at the end of her testimony, she tells Mr. Rosen, well, it could have happened in January 1993. Well, ladies and gentlemen, I would suggest to you, if you've had a life-threatening incident with a gun on your face, as she testified here, happened. And you certainly don't indicate that you come in here for the first time and tell this story. Obviously, it was not even important enough for her to know a date. She was the only person convicted of a crime. She also lied on an application under certification to Continental Airlines. She continued her distilling a plaque. That may not be enough, but this is the type as the government brings to you, that they want you to judge a person being credible. Well, use the same standard for the government's witnesses as you use the defense witnesses. Use the same standard. Do you rely on a convicted felon? It's a serious matter. It's a very serious matter. Ms. Dated Phil Spector for years, according to her, platonically. Yet when she finished this incident, she didn't know when it happened. You, I suggest, would know when it happened. I suggest any person, if it really happened. Nothing was reported to the police. There is no documentation or anything to support her at all. If anything happened between Philip Spector and Melissa Grosvenor, it clearly was an embellishment, and it had nothing to do with any motive to kill Lana Clarkson 10 years later. Stephanie Jennings. In 2003, she sold her story to a tabloid about an alleged incident that occurred in April of 1994. She had also been in a long-term dating relationship with Philip Spector, and supposedly she unlocked her leg against it and let him in with a gun. There were discrepancies whether the gun is pointed, not pointed. We do know that the police came, they found the gun, and we, 6 a.m. in the morning, managed the hotel, shipped her home. We know if the police never found the gun. Ladies and gentlemen, to this story, and in any event, whatever it is, it has nothing to do with the motive to kill Lana Clarkson 10 years later, a woman he only knew for 3 hours, rather than the person he had dated for several years. Jennings also continued her contact with Phil Spector for over a year after this alleged incident. And then she comes here with the compilation of edited sound bites for use language. And sure, we don't like what he used. Absolutely. Heated situation with somebody you've been dating gets really heated. But what's very interesting, if you listen to those, you heard them yesterday on these tapes that she edited and then saved for 8 or 9 years, you hear Philip say, I'm calling you back for the 7 messages or 7 calls you made me. Half a story, because what Stephanie Jennings didn't bring to you is what kind of calls she made to Phil Spector. Obviously, they were having problems. So you only had half the story. Half the story. You had edited tapes, half the story. Whatever happened between them is nothing to do with any motive to kill, really knew. Diane Ogden Holder. She reports an incident that allegedly occurred in 1982 and then 1989. Supposedly, she has a gun to her head, and then she continues on with Phil for 7 years for another incident. Does that make any sense to you? She knew him for years, and she said something very telling on the stand. She said Philip's conduct, he was mean to her, and it reminded her of something her stepfather did and how her stepfather treated her years ago. Look at that. In any event, if this incident occurred in 82 or 88 or 89, it had nothing to do with the death of Lana Clarkson 15 years later. And look at the size of all the women that you saw come in here. They were all fairly small and petite. The last one, 4'11", Deborah Robitaille, talked about 2 alleged incidents, one in the 70s, one sometime in the 80s. Now, you know that she sells her story all of a sudden to the tabloids after the Clarkson shooting. There's no police reports. There's nothing. There's nothing. Nothing about whether these incidents took place. And after the first one that she told you about, that she said she didn't feel physically threatened on, she comes back, and she back after the first one, and she leaves England. She comes back, and then she calls her good friend Philip for a job. Her good friend. Do you call somebody who's threatened you with your gun your good friend this time? By the way, when she says there's a second incident, she said she scolds him like a schoolboy, that she didn't think he meant her any harm. But in any event, if somebody had pointed a gun at you one time, would you go back for more? But more telling about Deborah Robitaille is the fact that in this courtroom, she got up and she said that the statements that she made, which were taped, were wrong. The statement she told you that Philip was not drunk, and then there's an information here he was drunk. The story's changed. That was wrong in the transcript function during some incidents. But Robitaille also tells you something, that she goes back to a party and she's the last woman standing. I think she was the last man standing, and she couldn't leave because she was working for Phil Spector, even though she had nothing to do with setting up the party. And didn't like it. She said it wasn't as good or something as the one she set up. If you think you're going to be threatened with being somebody, a party till 6 o'clock in the morning and be the person with the person that you're afraid of? Is that what you do? Well, we know in the tabloid story, because when she came up here, we know that when she gave the story to the tabloids, she even got the location of where Philip lived wrong in the alleged second incident. She said that he had lived in Alhambra, when in fact at the time he lived in Pasadena. She didn't even know where he lived. So you have to look at these stories. Whatever happened with her, it's been embellished to make Philip seem like a bad person, so that you don't like him. And again, these incidents occurred 20, 30 years ago, and somehow they supply a motive for Philip to kill Lana Clarkson on February 3rd, something that occurs in allegedly 1975 and in the early 80s, in the mid 80s, they supply a motive. Why did you hear so much about these women? Why did the government spend so much time trotting them out and discussing incidents from 10, 20, 30 years ago? If indeed they happened, they happened, they did it because they want you to hate Phil Spector. And they want you to mentally from saying he's a bad because the science doesn't support the fact. They want you to convict him on this alleged motive to kill, even though these women have nothing to do with the night in question, and even though there's not even police reports or anything to be able to check them on. In your search for the truth, you can't even go check some of this for Deborah Robitaille and Melissa Grosvenor and Diane Ogden-Halder. They're counting on you to be outraged. They're outraged with Phil science that they are unable to fill. They take 5 women out of his 63 years of life, take 5 women 63 years of life, and they say, look what bad person he is. They don't bring in, you heard Kathy Sullivan had a friend who went out with Philip a number of times. They don't bring her into you. And also, let's look at something else that the government had in their possession, if we could. Okay, one moment. And it's gonna, when Jennifer gets it up, it's gonna, something in their possession, they had a list. They had a list, which we're looking for. Okay, the list I showed you at the police station yesterday, which we're still looking for. Where's Michael Bay when you need him, huh? Well, let's discuss it while she's looking for it, and we're going to get a little help. But they had a list at the state. Some of the names you'll see were on that list were women. We're women. Janice, Nancy, June, Kaylee. Didn't work. Okay. We'll get there. You didn't hear. Okay. There's Rami, obviously met her. Nancy, okay. There's some men. June, Casey, Kaylee. You didn't hear any of these. Why select? Why bring you half a story about Philip Spector? Why select certain people? Why select a convicted felon?
I think the question is whether you can make that list non-blurry.
We try not to put their phone numbers in it. That's why we blurred it.
Okay.
It was the, we're trying to indifference to the,
Thank you.
okay, people on there. That's why we try to see the names and blur the rest of it. Here's Taylor, Casey, June. Okay, it is in evidence over here, and you'll be able to see it from the small photograph a little better. Nancy, Janice. But why bring you only select people? Man's 63 years old. How many dates has he had in his lifetime? How many relationships he's had in his lifetime? He was a top record producer, you heard, for a long period of time. Why bring you select people? Why bring you a conviction? Mr. Jackson dramatically showed clips of the testimony of 5 witnesses who testified about these past incidents with Philip, and asked you to find that this evidence proved that Philip shot Ms. Clarkson. But let's have the judge will instruct you with that testimony, and if I say anything that conflicts with what's going to instruct you. He will tell you that the evidence may be considered for one purpose and one purpose only, and that is to assist you in deciding whether on February 3rd, 2003, Philip had a motive. Philip had a motive, meaning a particular emotional state that might lead him to act in line with that emotion. Ladies and gentlemen, at one point in time, events at one point in time can tell you little about what a person is feeling on a particular occasion 10, 20, or 30 years later. And certainly, in this case, do not prove anything about emotional state beyond a reasonable doubt on February 3rd, 2003. The judgment of these women's testimony cannot define that Philip has a character or a disposition to commit. The state's argument the state's argument cannot suggest to you a plan or pattern. It has to suggest to you a motive, and then enough three Philip acted in light of that motive. Nothing else and nothing more. They have to prove that beyond a reasonable doubt. Let's discuss a little bit about the map of where we've been so far, because I know you've been listening to me for. I'm going to talk more in a bit about the law the judge will instruct you on, but let's have some context about where we've been. So when we discuss here the law, there is a little bit of the evidence review. The white jacket, sleeves, devoid of the blood you saw spattered all over Ms. Clark. The gun wiped off of blood spatter. You're going to do your investigation, not take Mr. Jackson's word for things, my word for things. You do your investigation. The struggle, no evidence of any struggle here for somebody that was going to fight for the life with a gun. An intraoral gunshot wound that was dead center, not moving around. If somebody just was trying to push a gun in the mouth. Blood spatter.
They wouldn't have let that in. Absolutely not. She would, if she had even much out, that's probably why she didn't testify. They would have gagged her so much, they wouldn't have let her say. Because he absolutely would have immediately been found guilty if she had said anything.
That would be closest to Phil Spector. That would be closest to him. Teeth going in the location her head was pointed at the time the gun was discharged. Not to the right, but this way, straight on to where she was sitting, propelled by the grasses, far, hitting the stairwell above the luminol that you can't rely on because out was not the position she was shot in. No doubt about that. DNA suggesting sexual contact, permissible. People do it. Adults do it. Nothing wrong with it. No motive for Phil Spector to force. And this is not government purposeful, but just a mindset to use only half of the evidence, not all of the evidence in looking at everything. More the government didn't tell you about. They didn't tell you that Philip Spector at the hospital had anything that would suggest that he was in a struggle, anything to suggest he did the shooting. They were looking for trace evidence. Gunshot residue, spatters we're looking for. Those are the hallmarks of how you show whether somebody shot somebody. Those are why all the experts speak the language. They were looking at that evidence to prove something. They did not find it, and you did not hear about it. Obviously, the DNA that you had a cross-examination, and there were certain government concessions. We know that there is a cloud that comes out of a gun. We absolutely know that. We know there was a psychological autopsy that was suggested and was not done after the determination of homicide was made, after the government started getting a hint from Ms. Clarkson's computer. And we know that there was no investigation into whether Ms. Clarkson could have been the other person who shot the gun here. Witnesses. We've discussed witnesses. There aren't any eyewitnesses. There aren't any eyewitnesses. The only witness who was near the scene is Mr. DeSouza, who said he heard a statement made, and you and I, at this point, discussed that at length both yesterday and together. Mr. DeSouza, whether or not he could have been sure, his language problems, the fact that he was not sure, and also other things with regard to him. And now the select past relationships of Phil Spector that are just selected, and whether or not they prove a motive, we suggest to you they don't. So in light of all that you and I have discussed in the past 2 days, let's talk a little bit about the law as you are going to get it from Judge Fiddler. And again, I caution you, if anything I say with regard to the law disagrees with what he says control. I'm going to discuss with you how I think you should view the law in light of the facts. When we started this case, you and voir dire, that if they had not proven the case beyond a reasonable doubt, that would be it. Let's go over a few of the elements of the law with you and understand how they apply to this case. First, there is a presumption of innocence. We don't presume guilt. Why don't we? Well, we don't bow under our Constitution in this country to pundits, press, public, police, and prosecutors to prejudge guilt. We don't do that. We go to search for the truth. People have been charged. That doesn't mean they're guilty. So why do we have a presumption of innocence? When the Constitution was to make sure the law could be controlled by kings, princes, but they had to be controlled by the citizens. That's you, the jurors. It's a quaint concept. We kind of think of the Constitution kind of quaint, but you are the Constitution, and you're it. Why do we have proof beyond a reasonable doubt to justify a conviction with all? Because it has serious consequences. Because we know there'll be instances in criminal cases. We know there'll be instances in criminal cases, and there'll be questions about who did what. And as a society, we have two choices. We can convict people, irrespective of their innocence, or we can acquit them because we don't know whether they're guilty or not. We don't know that. And we make a government go to its burden of proof because the consequences for everybody in society are serious. We thank God we have the Constitution. And you have to demand proof beyond a reasonable doubt. Because when you're protecting the rights of any defendant, not just Phil Spector, any jury is protecting the rights of everyone. So you hold them to their burden. Do not switch it to the defendant. We do not have to prove to you that Philip was innocent. They have to prove to you Philip was guilty beyond a reasonable doubt. They cannot say, just because he behaved badly 10, 20, or 30 years ago, that means he did something here and you must convict him. They must give you real proof that he committed, in this case, murder. Not just because or maybe confabulation or even condemnation, but real proof. That's what you're going to be looking for in that jury room. That's why defendants presumed innocent and presumed innocent until otherwise, unless you vote otherwise. If it has of proof. And boy, it's a tough job. You now have a tough job. You've been here for months and months. There's great pressure with regard to getting stories out. You know that he's been called a celebrity. We question you and voir dire that you against him. You would ignore those of you who had read anything that you had heard about in terms of gossip columns, in terms of people, victims, and turning scenarios. Your job is to not make good copy, good news, or good ratings. Your job is to seek the truth and do what's right based on what's presented in this courtroom. That's why, ladies and gentlemen, you have to respond to the rule of law, not the rule of ratings. That is why you are required to presume him innocent. What is reasonable doubt? Simply a doubt based on reason or common sense. It's a doubt that a reasonable person has after carefully weighing all the evidence. It's to hesitate in an act or a matter of greater importance in his personal life, in his or her personal life. Proof beyond a reasonable doubt must be so convincing that a reasonable person would not even hesitate to act upon the most important decisions in their life, like a medical decision or a career change or a decision made about one's children. It is not a whim. It is not speculation. It is not suspicion. And it is not concoction. It is not confabulation. It should carry the weight of absolute certainty. Circumstantial evidence. You're going to get a charge about circumstantial evidence because you've heard that this is a circumstantial evidence case. Is everything that is even remotely or tangentially related to the government's theory circumstantial evidence? Well, the law will say that you'll have it, and by the way, you're going to have the law in there with you. You're going to be able to see it. The law is going to discuss circumstantial evidence with you and tell you that if the facts support an inference that points to both guilt and points to both innocence, you must, like I repeat, you must to conclude that a fact necessary to find the defendant guilty has been proved. You must be convinced that the people have proved each and every fact essential to that conclusion. That's the first much. Each and every fact. You must prove them to hold them to each and every fact. That's what they told you, and that's what the judge is going to tell you. Before, you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved. Before, you must be convinced that the people have proved each and every fact essential to that conclusion beyond a reasonable doubt. Each and every fact. Beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude the defendant guilty, you must be convinced the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. You must, can I go back, please? You must be convinced that the only reasonable conclusion supported by the circumstantial evidence is the defendant is guilty. Must. If you can draw, and this is the most important one, if you can draw two or more reasonable conclusions from circumstantial evidence, and one of those reasonable conclusions points to innocence and the other to guilt, you must accept the one that points to innocence. So if that diaper is there and it suggests to you that Philip just wiped her face to help her, and that's a reasonable inference, you must take the reasonable inference that goes to innocence, not the inference that goes to guilt. It is a mandatory, and it's one of those four-letter words that in this case is extremely important. It may not be sexy, but it's important. However, when you're considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. If one of those reasonable conclusions points to innocence and the other to guilt, you must accept the one that points to innocence. You must accept the one that points to innocence. Very, very important. And the reason is because it's really easy to convict somebody if you don't like them very much. Really, really easy. However, as you learned when we were voir diring you, and you heard them, this already feels guilty because of the attention. You're not the media. And after I finish, the government's going to get to go again. They carry the burden of proof. They must prove to you Philip is guilty beyond a reasonable doubt. So they get a rebuttal argument. But as you are listening to the government, ask yourselves the following questions. They really their case, or have they just attacked what we do you? Are they presenting a case with a consistent theory? Are you certain, I mean really certain, that what they are telling you is actually what happened? Have they proven that fact to you beyond reasonable doubt? Are they presenting you mere possibilities, speculations, hypotheticals, or wishes? Or are they presenting you real, concrete certainty about what happened on February 3rd, 2003? Are they trying to play into your emotions? Or do you rely on the facts? More importantly, why have they never provided you an actual cogent explanation for how the shooting occurred? Where exactly was Phil Spector standing? What exactly happened? What exactly happened? Not he may have been holding the gun, somehow gone to. What exactly happened? And why, when such overwhelming scientific evidence showed, the evidence they were looking at, why, when it was so absent, showing his innocence, why didn't they take the issue of the psychological evidence seriously? Why didn't they go forward? Why didn't they look at it with serious professionals rather than waiting to this courtroom so that you had to look at it? So if you're conducting an objective investigation, why not look at Ms. Clarkson? Someone at the scene thinks he hears someone say he killed someone, and that's ends it? Then you think you have your suspect and you do no more, and all you do is prove that that's the truth? You don't look at just what may be the, you have to dig further. In this case, unfortunately, there was no digging further. We suggest to you, they suggested it themselves in the word celebrity, high profile, this is going to be a case. Everybody involved knew the import and the political implications. Let's be honest here. The police officer knew Mr. Fournier, when he was talking to D'Souza, what was at stake here. He knew he was dealing with a celebrity. We suggest to you that this blinded them, They decided to engage in the prosecution of a personality rather than examine the evidence the way it should be examined and the way it ought to be examined. They decided to give you stories rather than science. They decided to give you that speculation rather than certainty. And then they talk to you about little Bobby. And you can surmise because there's footprints in the snow that maybe little Bobby, Phil Spector, is guilty of something. Well, circumstantial evidence requires you to consider the fact that Bobby may also had a brother who had galoshes and went moving in the snow. That Bobby was asleep upstairs, and that somebody else, some other little child in the household, did those footprints. You have to look at everything. You can't just limit your vision to tunnel vision. Government failures to gather and protect evidence. Let's go to the screen now. As you know, there was a lot of evidence collection in this case. And in a full and fair investigation, you don't make excuses for what you don't do right. How much more evidence was there that proved Philip's innocence that could have been lost? They can't take advantage of these omissions in order to convict Philip. Now, we don't know. Just as they're alleging that something was taken from the scene, they don't know what it is and how it affected him. We don't know what all these effects would have happened. But we know that there are problems. Well, they didn't test Ms. Clarkson's contents for alcohol, which would have then revealed how much out of that tequila bottle had actually been drunk by her as opposed to Phil Spector. That would have given you a pretty good certainty as how much she had, because you knew, based on her blood alcohol, how many drinks she must have had, and you knew that there was stuff in her stomach. And then you can go back and say, well, did Spector drink anything of that tequila that night, or did he just have a sip out of a glass? They didn't perform the psychological autopsy. They didn't differentiate between the top and bottoms of Clarkson's hands when performing the GSR tests, which many agencies recognize is important. They didn't wear the protective coverings on their shoes at the scene, something they called the crime scene. They thought it was a crime scene, so that the blood spatter wouldn't be taken in. They didn't remove Miss Clarkson's jacket at the scene and didn't protect it from a purge, obliterating any proper analysis of blood spatter on the left side of the jacket here for us to look at. They didn't document major failure. The blood spatter at the scene that Lindemuth said she saw hands and arms. Didn't document, didn't do a drawing of it, and when she asked for the proper pictures to be taken, they didn't come out. They didn't come out. And some of it's so minute, as you've learned, as many investigators, that you need a loop to see it. And they saw it, and it wasn't documented. They didn't preserve the carving on it and then pull it up to take it. Once people walked on the scene, it didn't matter what was in the carpet, because it was gone or pushed into the carpet for luminol testing. Item 10, which they said was a small white particle. Is that small white particle part of the nail that they claim or seem to implicate that we took? They failed to preserve this white item on Miss Clarkson's shoe. We don't know what it was. Maybe it's nothing. Maybe it's nothing. We don't know. But it's not there. They didn't properly collect Philip's urine for a proper test if they're going to do blood alcohol, if they're going to do an alcohol extrapolation. They didn't put it in the right test tube. They didn't refrigerate it. And so that we are lost, you are lost, with the scientific objective evidence that all of you should have at this stage. Improper documentation of the blood spatter on the slip. There was, if you recall, there was a tape lift here taken. And Dr. Pena told you about meetings they had where they felt that had compromised their blood spatter investigation. Compromised it, because there was blood spatter all over the tape. Proper collection of blood spatter swabs on Lana Clarkson's wit. They took 3 samples off before they photographed and documented them. Again, affects the blood spatter evaluation, which luckily we still had the one directional spatter. Improper preservation of her hands when the body was moved from the scene. They weren't protected to look at the blood spatter when it gets back to the coroner's office. They failed to test what they thought was the white nail polish, part of the nail, from the tape lift. 4.5 years later, and yet want to try to allege or implicate taking an object from you that could be that. There was an actual pink stain on the lab jacket and a dropper of the stopper bottle on his jacket, the most important piece of evidence in this case. No one knows how the pink stain got there. It wasn't there when it was picked up. The gun was handled all over at the scene, and what you didn't see in those pictures was some of the pictures that I think you saw them later. Well, they took even the cartridges out. They took the cartridges out. They handled the gun all over the place. The gun had trace evidence on it. That's little tiny evidence. And they handled the gun all over the place. What else was taken off that gun? Accidentally, not intentionally, accidentally. You saw pictures where some of it was missing at the time it got to the lab. Now, these are some of the failures, okay, that they failed to do with regard to this case. And when you're prosecuting somebody for murder, you can't take advantage of those failures. You can't take advantage of those failures and say, well, ladies and gentlemen, because that switches the burden of proof. That switches the burden of proof. They have the burden of proof, not us. And then they try to come here, and Dr. Harold, Criminals Herald, comes here And we told you, they tested all of Mr. Spector's jacket for smokeless and non-smokeless particles. They looked at his shirt for trace evidence. They didn't find anything. Not GSR primer residue, but for particles. And in the notes, they don't have anything. They don't have anything that they prove to you is. Judge?
Yes. I'm sorry. Can you take a break? All right, we'll take a break at this time. Keep in mind the admonition will resume in about 10 minutes or so. Thank you. We're back on the record.
You want to get this moving. There are three things that I believe need to be cleared up, the last of which is the most egregious. There are two misstatements of law that Ms. Kenny Bodden has suggested. Number one, she indicated that the prosecution has to prove the facts underlying the 1101B women. She didn't call them 1101B women. She called them prior acts or whatever. The motive evidence beyond a reasonable doubt. That is an absolute incorrect statement of the law. I think Ms. Kenny Bodden knows that that's an incorrect statement of the law. We have to prove that to a preponderance of the evidence. I realize that
Oh, come on. StreamYard, I'm going to need therapy. StreamYard lulls me into a false sense of security and then betrays me. I'm going to need therapy. Okay, well, we got another hour of her, and then we get to go to a motions hearing, which I don't know how long that's going to be, and then we're done for the day. And then Monday, we get to listen to state's rebuttal. This is a trial that never ends. I thought for sure we would be done by now. And if this will load, I think the computer is sick of her voice. I think StreamYard is sick of her voice.
Present outside the presence of the jurors and the alternates, yes.
Briefly, I know that you want to get this moving. There are three things that I believe need to be cleared up, the last of which is the most egregious. Two statements of law that Ms. Kenny Bodden has stated to the jurors. Number one, she indicated that the prosecution has to prove the facts underlying the 1101B women. She didn't call them 1101B women. She called them prior acts or whatever. The motive evidence beyond a reasonable doubt. That is an absolute incorrect statement of the law. I think Ms. Kenny Bodden knows that that's an incorrect statement of the law. We have to prove that to a preponderance of the evidence. I realize that the jurors will be instructed on that. Ms. Kenny Bodden should not be allowed to blatantly misstate the law during the course of her argument. I think the court should correct that, not just have it correct that. The second statement of law, when Ms. Kenny Bodden began talking about our burden being beyond a reasonable doubt, and she specifically said absolute certainty. Then she followed it up with a concrete certainty. That is an absolutely incorrect statement of what the law is in California. The law in California, as a matter of fact, says it doesn't have to be to an absolute certainty. There's no such thing that's 100% certainty. I think that needs to be cleared up as well. The thing that was most troubling, however, is Ms. Kenny Bodden's lengthy dissertation about why we only brought in 5 women. Why did we select these women? Why select these women out of 63 years of Mr. Spector living? By the way, which is not in evidence. We don't know how old Mr. Spector is. That's the first thing. After 63 years of Mr. Spector's life, we selected 5 women. We didn't select 5 women, Judge. We stood up here. Mr. Dixon was blue in the face. Mr. Sortino was blue in the face, and I got a little peaked myself, screaming and crying to let us fully explore the defendant's past history of violence on what the court believed was admissible evidence. We sought as many as 14 other incidents where Mr. Spector has been violent with guns, where he's used guns, convictions he has suffered concerning gun use and assaults, ranging all the way back to the 70s. Those incidents, those prior incidents, were specifically ruled inadmissible. And then the defense was, and knowing exactly what Mr. Spector's history truly is, and knowing that the jury doesn't know that, she takes advantage and says, we just selected these 5 women and cajoled them into lying about Mr. Spector's past history. As I sit here, I don't know what the remedy could be. I know that that is absolutely improper. Ms. Kenny Bodden knows what she's been part of this litigation. She knows what this litigation has consisted of, and that was done to gain an advantage because she knows I can't stand up, or Mr. Dixon can't stand up and say, you know what, over his 63 years, you want to know what he's been doing? Let's talk about it. I can't do that. I think it was improper, 100% improper.
Okay, I'll hear from the defense.
On the first point, Your Honor, the law is, as you will give it to the jury, that the jury may not even consider an uncharged offense unless it's proved by a preponderance of the evidence.
That's correct.
That's correct, and the court will state it. However, the law also is, and this is clear in the notes to CalCrim, that if the government is going to rely on any fact for the purpose of convicting as part of a set of circumstances, each essential fact has to be proved beyond a reasonable doubt. So they'll get the instruction. The preponderance of the evidence is actually a hurdle for the defendant's benefit. They look at it unless you get to a preponderance. If you get to a preponderance, then it's in the ballgame fact that you can consider. But nothing changes the fact that the reasonable doubt instruction says that if it is a fact you're going to rely on to convict, then you have to prove it beyond reasonable doubt. If we look at the 375 discussion in the footnotes there, they make it clear that there's this tension between the standard that you need to get uncharged defense evidence into evidence and the standard that you need to rely on it to convict. So the court will give the jury the law, and they'll have the principles. Kenny Bodden said nothing inappropriate, and if this court were to say to the jury, you could rely on one of these incidents to convict based on only a preponderance, the court isn't going to want to do that in the face of the principle, the well-established principle that every fact essential to a conviction has to be proved beyond a reasonable doubt. So that's just an area where they'll get the law. Ms. Kenny Bodden has been clear that if they're talking about the law, it's up to the court and the court's instructions. As to the second point, we agree that Ms. Kenny Bodden misused the word absolute at some point. She intends to read the reasonable doubt instruction to the jury and clear that up. And of course, again, she has said conflict instructions and those that control, but she will actually read the reasonable doubt instruction. On the third, the thrust of that argument, Mr. Spector has gone with many women in the course of his entire life, and there are many of these women who would speak favorably of him, and these 5 women are merely a small number of the people that he's associated with in his life. And like Mr. Jackson, I don't know what the court would say to the jury in this regard. I think it was a fair argument that these are not certainly a full cross-section of women that Mr. Spector has known in his life.
I would just follow that up with one specific example. You know this. I don't know if Mr. Reardon does. Probably, I would imagine he wouldn't know this particular incident. One of the things Ms. Kenny Bodden says is, why would Mr. Spector why would he ever pull a gun on a woman he didn't know? All of these other women he knew. Why would he pull a gun on Lana Clarkson, a woman he barely knew? Dick Strand was specifically requested to be an admissible 1101B incident. He had never met Deborah Strand in his life. Showed up at a party. He has some worse temper. Gets a gun pointed right in her forehead. These are things that Ms. Kenny Bodden knows. The defense team has all of this information. Yet they're making arguments that they know we can't rebut because, and they're just factually inaccurate. They're factually incorrect, and counsel knows it.
Trying to think of a remedy. because the Strand incident is an absolute misstatement of taking advantage of a ruling that I made in the defense's favor, and the law does not allow you to do that. The question, yes, go ahead, Mr. Bruno. Yes, you.
I don't mean to interrupt, but there is a difference. The court has narrowed this evidence to evidence showing a motive, which could be articulated. I think the court, perhaps, or Mr. Jackson, articulated it as a motive to prevent women from leaving when he's alone with them, in some private place. Didn't exclude any incident at all similar to the ones that were admitted and to the ones that are in the category that's completely distinguishable. It was a public event. It was a party. They weren't alone together. There was no relationship of any kind. And I mean, it's just different. It isn't similar to saying he's dated a lot of other women, and these are the only incidents that have come to pass. So she's talking about a subset of a subset.
Well, then you know what? She needs to make it clear, and you better re-argue that to the jury and make it very clear what you're talking about. And if I think it's off topic, I'm going to have to think of what to do. I'll give you an opportunity, and I'll make a determination whether I think it's sufficient. You can take the opportunity to clean up the reasonable doubt instruction, but since there doesn't appear to be an agreement as far as the uncharged offenses, I'm going to admonish the jury as to what they're going to be instructed, because I think that's a complete misstatement. I think it's just, and I don't mean it in a pejorative sense, but I think it's disingenuous to say, well, that's not really a misstatement. That's okay. That's ultimately there's this tension. Yes, there's a tension, but it's very clear as to how a preponderance applies. So I'm going to read that part of the instruction to them.
Your Honor, I would ask that if you're going to read from 375 and read the phrase that says, if you wish, in order to consider this, you have to find it by a preponderance, that you also read the ultimate paragraph, which says that, of course, this isn't enough to...
Into the jury stuff where they're arguing back and forth that was improper argument. Then there needs to be an instruction made. I love this stuff because this is the stuff that the jury doesn't get to see. And sometimes I think the stuff that the jury doesn't get to see that they need to see to make it more of a fair trial. But then there are times when they shouldn't see it. And what's happening right now is something that the jury should not see. They're cleaning up mistakes and things, petty little nitpicks at each other that the jury should not see. And they're trying to fix it without the jury knowing that it happened, that they were nitpicking at each other. And I find this part fascinating. I think Wiggles is getting a little bored with it, but this is my, I won't say favorite part, but I really do enjoy this kind of stuff. I hate confrontations, and I cannot believe that I ever wanted to do this for a living. This was like my fallback. If I didn't like being a nurse, this is what I was going to do. There's no way I could do this. I can't imagine arguing with someone hour after hour after hour and then like having to work with the person and be a colleague with the person, yet you're on opposite side. Like I wouldn't be able to separate that in my head. Because they're like snarking at each other, yet they're colleagues and they respect each other. And like Judy said, when Jackson was doing his closing arguments and all the stuff he said about Linda, and then she gave him that dirty look, and Judy mentioned, oh, she spoke very highly of him during the Karen Reed trial. And she did. Like, I watched some of the stuff she said during the Karen Reed trial. She really, really did. And I'm just like, how do you reconcile, like, the snark and the dirty looks and then go on to work together and say you really respect the person? Like, how do you separate that? I'm not that type of person. I would have been a horrible lawyer, but I like this stuff. I really enjoy this part.
And it has to be, the charge has to be proved beyond a reasonable doubt.
What I'm going to tell the jury that how to consider that instruction in light of all the other instructions. That's not the entire instruction, and they will be given the entire instruction when I instruct.
That's all I have to
All right, thank you. Let's bring out the jurors and the alternates. I recollect the alternates. And ladies and gentlemen, to read part of an instruction to you, I believe there was a misstatement during Kenny Bob's argument concerning the evidence.
Look, the jury instructions on his desk. Good Lord. That's a lot of instructions.
And then tell you briefly how it's going to fit in and how you consider it. And then when you actually hear the instruction, it'll put everything into context to you.
No, I can't.
Let me just read a portion of...
I can't speed it up because it's on the website. It's not on YouTube.
This instruction. The people have presented evidence of uncharged offenses, and you know the witnesses that we're talking about. By the defendant that was not...
But we have to stop in an hour for the motions hearing on Sheriff Sean Mickey Steins. So, we've only got another hour of this. And I hope the motion's like 30 minutes and then that's it. But we're going to stop after the motion.
This evidence only if the people have proved by a preponderance of the evidence that the defendant in fact committed the uncharged offenses. Proof by a preponderance of the evidence is a different burden of proof than proof beyond a reasonable doubt. A fact is proved.
Yeah, Judy. I've never seen a trial with this long of closings before. Jackson went 6 hours. This is 6 hours. And now we still have the rebuttal from the state. This is why it's taken us so long to get through these. Between the tech problems and doing other trials at the same time, this was not, I thought we'd be done by now, but nope. This is crazy.
By a preponderance of the evidence if you conclude that it is more likely than not that the fact is true. If the people have not met this burden, you must disregard the evidence entirely. Later on in the instruction, when it is read to you, it will then tell you if the people have met this burden, how to consider this evidence in light of all the other evidence. So I just wanted to correct that. And with that in mind, you may resume your argument. Thank you.
That's why he's the judge. But you're still going to have to determine, ladies and gentlemen, whether the state government proves their case beyond a reasonable doubt, and whether or not you have any reason, which is proof beyond a reasonable doubt is due with binding conviction that the charge is true. You don't need absolute certainty, but inviting conviction that the charge is true. And when you're discussing with regard to that, and you're looking at motives, remember the government's claim is that Spector, when he's privately with a woman, has a motive. He wants to keep them in their house, and he emotionally snaps and he pulls out a gun to try to keep them. So when you're looking at these five women who came for you, you have to see again whether that motive is enough to explain what could possibly have happened and why Phil Spector would have done anything on February 3rd, 2003. And the judge is going to charge you a long time on that. You're going to get the full legal instruction on that. And you listen to him with regard to the law. That's why he wears the black robes and I wear the black dress. Now, when we left, we were discussing, in light of this whole idea of things that the government had or had not done, the fact that they were looking for these burnt and unburned particles, part of GSR. It's not the barium, lead, or antimony, again. It's the part of GSR that comes out of that cloud that's in that gun. And what was interesting was, if you look on Dr. Herald, Criminals Herald, we were questioning her because there was no indication that they had found anything, certainly proven anything with regard to his jacket. So question, and in fact your notes, this is your page 213, I think she said she had 400 and some pages, but our page 433, on 5/21/03, you wrote, quote, no smokeless powder seen on surfaces of jacket inside or out. Did you not? That's what she wrote in her notes. Answer, well, That's from looking at the actual jacket. That is different than the sample that was taken from the cuffs of the jacket, which was what I was reading before. Question, ma'am, we're in the year 2007. In the middle of this trial, are you telling this jury that you've never tested that disc? And that was a disc, a little sticky disc of Mr. Spector's sleeve. Materials on it, because if you look at the disc, you to suggest to you that maybe there was half a piece of a smokeless particle on a disc that came off his jacket, but she didn't know what it was because she hadn't tested it. Ladies and gentlemen, that's the absence of proof. You can't say, well, I didn't test it, but maybe it could be there. Maybe it could be there, especially when your notes say you're looking for the jacket and there was none of unburnt particles inside out, and they also looked on her clothes. So, ladies and gentlemen, you can't allow the government to switch the burden of proof to us. You can't allow them to switch the burden of proof to us. If we've done something wrong, if we, for instance, intentionally, erroneously, negligently withheld discovery for 24 hours or whatever, that cannot affect Phil Spector. That should not affect Phil Spector, because they have the burden in this trial. In this trial, they have the burden to prove, and they can't say, well, we couldn't prove it because we didn't have everything, where we were unfairly treated.
Hey, Michelle.
You can take it into account. The judge is going to tell you about it. There are essential facts of this case beyond a reasonable doubt. Now, in addition to that, we've also discussed at great length, and I'd like to summarize from them to you now, the science that proves Philip's innocence. In addition to all the problems with would have.
It's a good thing. Remember when the power went out the other day? He hooked up the generator, and it worked, but there was something wrong with the carburetor, and he fixed it. So it was a good thing that the electricity went out the other day, because he was able to figure out that there was something wrong with the generator we didn't know about. Hey, Donald. So now we're prepared. He just needs to go get some more bottled water and some more gas for the generator. But I think it's turning away from Florida, though.
Further pointed to Philip's innocence, based on the fact that you could infer blood spatter on, like, for instance, then you had evidence that there was blood on her hand and on her wrist. The scientific evidence that you do have conclusive shows that Philip did not kill him. Does it? Because you're going to mention yourself. Well, the defense told me. I suggest to you that when you look at it, when you seek for the truth, you will determine yes. So let's go through some of them. White jacket. No blood spatter on the right sleeve or cuff below the elbow. No blood spatter on the left sleeve or below the elbow. It was only a transfer stain. No blood spatter on the inside of the right cuff. It was only 2 transfer stains.
Because he took it off. Duh.
The distribution of the blood spatter was inconsistent by the jacket being worn by a shooter. No unburnt or burnt smokeless particles. We just talked about a gunpowder on the jacket gunpowder. They didn't test for GSR, so there's no proof of any GSR. No tissue on the left or right sleeves. No tissue inside the left or right sleeves. No tissue on any other area of the white jacket. One blood spatter on the back of the right arm sleeve tricep indicates indicating that the arm was raised above his head, covering his eyes. Shirt. No gunpowder, smokeless or unburnt particles were found. Never tested for GSR. GSR because they never tested for it, so they couldn't bring that proof before you. No tissue. No blood spatter on the shirt. Dr. Harold said she looked at every inch. No blood spatter on the inside areas or left of right shirt cuffs.
Gee, I wonder if he changed his shirt.
Pants. No unburned particles of gunpowder. No burnt particles of gunpowder. They didn't test for GSR, so there's no GSR that could be bought before you. No tissue on any area. No blood spatter on any area. Shoes. They didn't collect the shoes. So what do you know about the shoes? You have no evidence. You have no evidence of particles of gunpowder because the cops had them. And they looked at him, they looked fine, they gave him back. So you have no evidence of that. None of that before you. There's no evidence of GSR on the shoes, no tissue on evidence of tissue. Would they had seen them? On Philip.
Yay, Jill's back. Can anybody tell from that picture of him coming out of House of Blues? Can anybody tell what he's wearing? Can anybody really tell if he's wearing the same outfit? Because maybe he changed. He had plenty of time. He cleaned up. We all know. He wet that diaper. Why does a grown man have a diaper? A cloth baby diaper. He wet the diaper. He wiped her face off with it. We know that. He had plenty of time to change clothes. Do we know? Maybe he had another outfit that was very, very similar to the one. Maybe he took the jacket off and changed the clothes underneath, and it was very similar to the ones that he had on. And he put the jacket back on over the new.
He was looking with a light source in his nose, in his ears. No evidence that there was any burnt or unburnt particles of GSR, his nose, ears, hair. She looked all around his body. No tissue in his hair.
Yeah, she doesn't have the dynamics that Alan Jackson does. She doesn't, like, her voice is kind of monotone. Like, she doesn't change the levels. Like, AJ's really dramatic, and he changes the levels. He gets louder, he gets softer, he has dramatic pauses. She kind of, like, drones. You know? Like, drones. I mean, I like her as an attorney. I like her very much, but I enjoyed Alan Jackson's closing much better. It didn't feel like 6 hours. It was enjoyable. This is not. This is... My ears are bleeding. Like, make it stop.
No blood in his nose. No blood in his hair that you were aware of. No blood in his ears. No fine tooth particles found on him. Remember, Dr. Harold, Criminals Herald, said she was looking for particles on him and his jacket, on his jacket.
Court TV, fix your website.
Pants, no fine tooth particles on his shirt, no fine tooth particles on his clothing. No trace evidence anywhere on his body. No trace of that. No injury from a struggle of Clarkson found in his body. No DNA from Clarkson under his fingernails. No blood.
I don't understand. Why do you do this? I have two things. No, I have three. I thought it was run back. Wow. Okay. No, I love the outside the presence of the jury part. I want this to quit buffering.
Gun wound was 1.5 inches back of the tongue, meaning the barrel was pretty much all the way in her mouth. Stippling on the inside of her upper and lower lips, gums showing the gun that her lips were loosely closed around the barrel. Many GSR particles on the backs of both hands. No bullet wipe on the teeth. No broken, chipped, or cracked teeth from the outside in. Teeth blown out directly in front of her.
Dang it.
No foreign DNA under her fingernails. No blood under her fingernails from Phil Spector. No tissue under her fingernails indicating she grabbed, struggled with Phil Spector. No ripped pantyhose. No torn clothing. Blood spatter on both wrists. Blood spatter on both hands. Blood spatter on left hand showing directionality this way, not grabbing something out here. Shattered piece of acrylic nail polish, characteristic of a self-inflicted wound. Thumbing the gum. Nail polish fragment, allegedly found on tape lift a slip dress that it looked to them to be like, and they never tested it. White polish. Clarkson Spector comparison. Relative distribution of gunpowder on clothing. Relative distribution of gunpowder on hands.
I wish they quit.
Relative distribution of GSR on clothing. You didn't hear any about him.
It is a dress. Call it a dress. It's not a slip dress. It's a dress. They keep acting like the woman went out in her underwear. It is a dress.
She clearly would have been covered with it, irrespective of testing or not testing. The relative distribution on her hand, she had many particles. He had one. Disparity in body size and physical condition. Use of medication by Mr. Spector that causes tremors. Disparity in the distribution and pattern of blood spatter on the clothing. Disparity in distribution of the pattern, blood spatter on the hands. There's no indication he ever had any spatter on his hands because it was on his hands. It likely would have to be here if he were the shooter. A scene. Picture frames on credenza not disturbed. Lamp on credenza intact. No furniture moved or disturbed. Eyelashes placed clearly by Ms. Clarkson on the toilet. Brandy glasses left in bathroom indicating mixed DNA, both shared glasses, nothing broken, nothing thrown. DNA. No DNA of Spector found on the cartridges. No DNA of Spector attributable to Spector found on the gun. DNA from Clarkson found on the bullets, including they swabbed the void cartridge. DNA from Clarkson found on non-blood-stained areas of the gun. On the grip, they swabbed the grip. They swabbed, I recall Mr. Renteria, many different areas. The grip, the barrel, everything to get a sampling. So, and yes, I guess I clearly misspoke when I said there were only 10 points of science that proved Philip Spector was innocent when I opened to you. Because this is the trace evidence and the evidence that investigators look for. And there's over 80 that proves his innocence. In addition, you're going to see all these factors. I submit to you, we submit to you, each and every one alone, each and every one alone gives you reasonable doubt. Just take a look at them. It's a summary of what we have been discussing. Jennifer, when you're finished, let me know. Thank you. Now, the third thing that we also want to summarize for you that we discussed, and we discussed a little bit yesterday about what was going on in Ms. Clarkson's life, out of her own words, but you also heard in this trial other people's words about what they said about the time that she died and what she was going through. Keep going. We know from Jennifer Hayes. Well, we know that Ms. Clarkson complained about not having money for food nor rent on a regular basis. She wanted kids. She complained about the House of Blues being humiliated, pulling herself up by her bootstraps, trying to make you believe she was happy and proud. That she was upset about no one was interested in the video, left the meeting crying, told it was not quality work. Towards the end of 02 and 03, she was in dire financial straits. She was upset about the loss of a love relationship that was going to save her from all this. She took Vicodin. Jennifer Hayes said, I've seen her take a lot of pills. Once or twice when she was with her, probably at the clubs. At the baby shower, Ms. Clarkson was drinking, the only one taking painkillers. Lana wanted fame more than anything else, was giving up hope. She told her at the end of 2002 or into January 2003, I've had it. The lowest she ever saw her in her whole life, sobbing her eyes out. Horrible to watch. Jennifer Hayes said, game-face hope is different than long-term hope. About the prosecution statement that Ms. Clarkson never gave up hope, I guess it was Dr. Pena's statement. I totally disagree with that. When she was happy and had her game face on, she made you believe she was great, but she could snap and then become the saddest person she ever saw. Hayes didn't know what to do, just didn't have any answers. And she told us at the end that she was very, 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 very depressed. David Shapiro saw her video. Ms. Clarkson told him she had to borrow $30,000 to $40,000 to make it and didn't have the ability to pay it back. Marilyn Monroe was her idol. That Ms. Clarkson was disappointed in the reaction to her video. Mentioned several times she was depressed about her career, felt she could have been further along, and as she got older, it seemed less likely. Spoke about times about living very close to the edge, her ability to meet her financial obligations. Fairly frequently asked to borrow money from him. He asked for a few $100s just to pay her rent. And then when he couldn't lend it to her, she felt betrayed. At the depression level she experienced, that she felt she was so tired of struggling. Every time he talked to her, she was always in the dumps. He checked with her emails. She told him she had nowhere else to turn, no phone. Good thing, because he couldn't hear her tears. And this is the email that she wrote. She was going to tidy her affairs and chuck it all. Never landed any big roles, nothing paying at the time. He knew her, December, January. And then she had moments of depression. John Barron's. In January 2003, Lana heard voices on a stage that weren't there, fired from her part playing her lifetime idol, Marilyn Monroe. They asked him for Vicodin. Idolized Marilyn, we've talked about. Likens her own life to Marilyn. He felt that she was overbearing, obviously, with all the stress, who wouldn't be? Greg Sims, crying for prolonged periods of time, described her as depressed, desperate, and despondent. General state of unhappiness, she told him, about everything. This is only about 5 days before she died, 5 or 6 days. Her business, her career, and her family. Hated everybody in the business. Pi and Lana were best friends. When Lana was drunk and despondent in his hotel room, Pi came to pick her up. He told her she needed to get help. Pumpkin pie. Lana said she couldn't get a job, had financial problems, was depressed, was not pleased, upset with her failed relationship with her boyfriend. Would drink a lot. Took that first happy, then humiliated. She was upset over Michael Bay dissing her. And ladies and gentlemen, he obviously didn't see her. I think anybody was lying about that night.
I thought it was the CIA.
He just didn't see her, and she probably took it as a diss. He didn't recognize her. But she was sick of all the people in this town. Could you go back? So she didn't want to be here anymore. Put on a happy face in the worst of times. Didn't have a moderation switch when she drank. And then said, I don't want to live anymore. I don't want to be in this town. I want to end it. I don't want to be here anymore. Now, right, Jennifer? Let's go past that if we could. What do we have at the end of all this, the trial? Well, we have that the government could not tell you that Philip Spector's hand was on the gun. Tell me when you're ready, please, Jennifer. In his opening statement, Mr. Jackson said to you, the opening statements aren't evidence, but they provide you kind of with a roadmap, as we told you. Mr. Jackson said to you, the evidence is going to paint a picture of a man who on February 12th inside her mouth and shot her to death. The defendant pulled his gun out of his bureau drawer, secured in his holster, and loaded with his bullets, and he shot Lana Clarkson through the mouth, a single gunshot. Put a loaded pistol in her mouth and shot her to death. Ladies and gentlemen, did you hear any scientific evidence from any of their people that even told you they could establish that Philip Spector was holding the gun? The government said to you through Dr. Pena that he obviously pushed a gun into her mouth because, remember, she had a bruise, according to them, a bruise on her tongue indicating he shoved the gun in her mouth. Ladies and gentlemen, when you listen, and again, I don't get to talk to you, when you listen to the rebuttal that may come after this argument, listen to whether there's any different theories here propounded by the government at this time. Did the pus get in her mouth because she slapped his hand? Did the gun get in her mouth because it fit? Did the gun get in her mouth in some other way? They told you that they thought you put
StreamYard trying to hush me again. So she slapped the gun, and it just happened. end up in her mouth. While she's slapping the gun away, she's slapping the gun away and it just ends up in her mouth. Okay, sure. That's how it happened.
Not that it fell in her mouth or anything. Listen and hold them to the standard of proving race beyond doubt. I'd like to show you a summary, a video montage. And again, these clips are not evidence in the sense that you're going to rely on your own recollection of what people said. These are taken from TV, just like the clips you saw the other day. A little montage of what the government scientists told you they couldn't do, which is show you that Phil Spector fired that gun February 3rd. You are not the one.
Of reports in this case, correct?
Yes.
In any of your final reports that were peer-reviewed, as you told us, did you conclude with any scientific certainty that Phil Spector pulled the trigger of that Colt Cobra on February 3rd, 2003?
No.
Thank you.
So when Mr. Jackson came up to you and stood right upon here, you don't know, based on your opinion, whether somebody came up and did this, do you?
You say you have to describe it.
With your arms, with his arms up.
Y'all, we need to make and market a true crime clue game. Jim on the grassy knoll with an umbrella. That would be so great, wouldn't it? Like Dahmer in the kitchen with an axe. we should do that. We should make up a whole bunch of things for a Clue true crime game.
You may answer. No, I do not.
Period of 4 years.
Certainly on and off.
On and off 4 years. And with all the testing that you did on this gun as the firearms expert and all the descriptions in the summary that Mr. Jackson just gave you, did you put anywhere in your notes any conclusion as to who fired this gun on February 3rd, 2003?
I did not.
Now,
Yes.
and after all the testing for a period of over 4 years, as of this date, you cannot say whose
Easy in the backyard with the balloon animal.
finger was on the trigger when that gun went off, correct?
That is correct.
I have nothing further, thank you.
Right. That's correct. Or she could have got the particles just by firing.
That's correct.
And there's no sign.
Okay.
That's correct.
Okay. From the medical findings, you can't tell whether Lana Clarkson was or was not holding the gun.
Correct.
I have to go by the picture.
Okay. And was the blood spatter that you saw here that you previously testified about, was it consistent with her holding the weapon?
Yes.
Did it help you understand how she... Is that inconsistent with somebody firing a gun?
Objection.
With their right hand?
Objection. It's culture. Calls for, there's no foundation for it. He's not a backstabber expert.
No, but he has made and used certain things to form his opinion. It goes to the weight of his opinion as opposed to whether he can offer the opinion. I'm going to allow him to answer.
It is consistent with him not holding the gun, because not firing the gun. Holding the gun, I don't know, but up in the neck or upper chest.
Not consistent with holding and shooting a weapon.
That's correct. Not consistent with holding or shooting a weapon.
Okay, so even though that won't be weighted in this case, is that
Correct.
And what did that scientific evidence tell you as to the question in this case that you were asked to answer, who was holding the gun when it was fired?
Well, according to the physical or scientific evidence, this is as I said before, a self-inflicted shot. That means Ms. Clarkson held the gun and fired.
Was the first thing you said intraoral gunshot wound, and therefore that plays into your opinion that she was holding the gun?
Yes, sir.
Okay, and in your mind, that's not.
Is there any question in your mind, Dr. Budden, that she did shoot herself, whether it was intentional or not?
No, there's no question that she, her hand was on the gun and pressed the trigger at the time of
that we've talked about. What is your final conclusion as to the manner of death in this case as to Lana Clarkson that occurred on the 3rd of February of 2003?
My conclusion is that Ms. Clarkson died of a self-inflicted gunshot wound of the mouth and...
Jackson, our hypotheticals, did you make a determination that this jacket's right sleeve was up to the mouth and the nose, holding the gun of the decedent?
No.
Is there any scientific evidence on that right sleeve that would allow you to conclude that?
No.
And then one final question, is there any scientific evidence in the blood spatter area to support these two sleeves being up to somebody's mouth and shooting a gun?
No, the bloodstain evidence, the bloodstain evidence.
We began talking to you in our opening statement, and we're going to end talking to you about the white jacket. This is the cone of what comes out. This is the jacket with just the arrows removed. The blood spatter that existed was on this jacket, just the arrows removed. Look at what happens here, and look at what you don't see there. There's somebody up in somebody's face holding a gun. I have to give you some final thoughts. Winston Churchill used to say that the quality of a nation's civilization can be measured by the methods its police use in their enforcement of criminal laws. I suggest to you, by that yardstick, that if we don't go with the scientific evidence here, that we're in deep trouble. You can't circumvent the Constitution. You must find Philip guilty beyond a reasonable doubt if you're going to find him guilty. We have sacred laws in this country that govern our country, that ensure our civil rights. And you, in doing your duty here for these months and going in there, you are the one that are going to protect those freedoms that we so value. Ask yourselves, what do you know about this investigation? What did you want to know about this investigation? What was proven in this investigation? Are you satisfied? Can you be satisfied? Can you ratify the actions of this investigation? Or do you have to look at exactly what you have? Based on the evidence, you cannot condone them. Cannot condone them because there is no scientific evidence to support Phil Spector's guilt beyond a reasonable doubt. The police had a problem. At Phil Spector's residence, there was a simple shooting. A beautiful woman was dead in the house of a music producer. It seemed an easy case at first glance. But good police work requires diligence, and it requires attention to detail, and requires careful analysis, and it requires looking for the facts, which we ask you to do, not an easy story. Ladies and gentlemen, you've seen, and you'll make your determination that whether it happened here, we suggest to you it did not. Instead of asking the hard questions, seeking the truth, digging around unusual suspects. With one person dead and another's life on the line, they decided Philip Spector was the murderer within 15 minutes of the so-called investigation. The police had declared this a homicide. 15 minutes to conclude that he was guilty. And you've seen how much has been out there just in months with regard to hear what they didn't have and what they did have. After the police decided he was guilty, Did they comb the earth to see, challenge and verify some of a person's worst detractors? Incidents from 15 years ago, 30 years ago, 10 years ago. Ladies and gentlemen, the absence of evidence in this matter is a fact. The absence of evidence is a fact. It is not an ethereal concept that maybe there was evidence there and we didn't find it. The absence of evidence means the government cannot prove their case. Phil Spector is somebody that regardless of how much money he has, regardless of how likable he has, regardless of how many people have been trotted out to a dead person, has to have and deserves the same considerations and rights of due process that we expect in our system. That's why you're here, to make sure the government proves their case beyond a reasonable doubt. The government yesterday told you that their job is to seek justice for those who can't get it for themselves. That is not your job. That's the job, I suggest to you, of a vigilante. And you are not vigilantes. Your job is to seek and preserve the rights of this defendant to get a fair trial, making sure the government fulfills its burden by proving a case beyond a reasonable doubt. That is our Constitution, and that is all of our jobs. This is finally the moment which you, as citizens of this nation, get to watch democracy in action because you become democracy in action. The weight of any juror is to decide if a government has proven a case beyond a reasonable doubt. Vilification is not enough. Is not enough. Do you favor the worst characteristics of somebody over science? Should the words of everyone you've offended, people that you've offended in your life, with tall tales, overcome science? Overcome what we spend millions of dollars for, the state spends for having labs to look for trace evidence to prove crimes? We don't convict people in this country because we don't like them, we don't like their hair, we don't like how they look, we don't like their clothes. As purveyors of justice, you are the jury and you have to follow the burdens and the law the judge will give you. You can't, denigration cannot form the basis of a conviction. You have to look at the facts. You have to look at all the facts, not those just that are being magnified or possibly embellished or possibly made up by certain people on the stand that have motives to lie, mistake. Character is to keep the government to its burden. And this is the time that you get to decide how your country behaves with respect to the judicial system. Because if you don't follow the judge's instructions on the law, you have really let everybody down. Because you have to follow the law and you have to keep them to their burden, not putting it on us. Ladies and gentlemen, you have a moral, legal, and ethical obligation. We suggest, based on the evidence, to recognize reasonable doubt in this case. And as a side note, I would like to say something. Mr. Jackson, the other day, as you know, attacked, and he has every right to do that, he attacked the ability of Dr. Bodden, my husband, to be biased or not. Witnesses don't decide to call themselves. Lawyers decide to call witnesses. Not to hide anything from you. And we hope we didn't by calling him to the stand. We have an obligation on behalf of our client to share the experience of every expert who has knowledge, especially when that expert was in a case for 2 years that predated the involvement, in this case, of me. None of us should be afraid, and when you go in that jury room, none of you should be afraid if you have a differing of opinion to stand up and discuss your opinion, just because you may be attacked on the basis of what you are, your ethics, or what you believe should be your personal ethics. That is the real conflict. That would be a conflict of morality. that really would be a problem. Because you are here, you judge everyone. You get to judge everyone, good, bad, and different, as to whether you believe them or whether you don't believe them. That's why it's important that all the facts of any investigation from any person come to you. This case exemplifies reasonable doubt. Again, the white jacket that you saw. Ladies and gentlemen, as I said to you before, you are now, I'm turning you over to become the investigators. When I sit down, I'm finished, don't get a chance to speak to you, and you will soon get the case. It's now February 3rd, 2003, at 1700 Grandview Avenue in Alhambra, California. You seek the truth. After you review the evidence, here is the coroner's data sheet that was filled in back in 2003. They had checked homicide. You're going to get the chance to make things right. You're going to get the chance to check questionable accident, suicide, or accident. In checking that box, you also check the box for Phil Spector's innocence. It's now time for you to make things right. Thank you for your time and your patience, your courtesy.
Thank you, Mr. Dixon.
Well, we actually need one to set up and a few moments with the court.
Okay, so would you like to actually start then at I'm going to say 1:30. It's actually going to be a minimum of 1:45. I have 11 matters on my calendar. I pushed them over to this afternoon. They're all going to be continued. I'm going to take them next door in Judge Bauer's courtroom. He's been kind enough to let me do that so people can come in this courtroom. I just don't know whether we can do it in 15 minutes. I'm going to bring the jury back at 1:45. I may be late. Keep in mind the admonition. We'll see you at 1:45 this afternoon. Thank you.
We're going to stop. This is a good place to stop, even though the video's not done. We're going to stop right there. And hey guys, we are going to stop right there, and we are going to go watch the motions hearing in the Sheriff Mickey Stein's case. So it will direct you over to that live stream, and that is going to start at 1. So I'm going to take a quick break, and I will see you over there in a few minutes. And then we're going to call it a day, and I'm going to do some work on the members only live stream that we're going to do tomorrow, and maybe some stuff to get ready for the Adelson trial next week. And then we will finish. I keep saying we're going to finish Phil Spector, but at this point, I don't know if we're ever going to be done with it. So we'll try to finish up Phil Spector on Monday. So I will see you guys in a few minutes, and you will be redirected to the Mickey Stein's hearing.